We are live.
Thank you, Sasha. Good evening. My name is Anna Sengupta. I am the Assistant Director of Arts and Culture at the Metropolitan Area Planning Council. Thank you for attending and tuning into tonight's proceedings. These proceedings needed to be rescheduled due to a disruption or Zoom bombing of the hearing that was held on June 2nd, 2021 at 7:30 p.m. The timing of this hearing represents the earliest date possible within legal notice requirements of open meeting law and participant availability. To minimize the potential for additional disruption, tonight's proceedings are being held in a webinar format. Public comment was received in writing prior to the meeting and shared with the panelists. Public access to the meeting is being provided via a live stream to the MAPC Metro Boston YouTube channel. Tonight's proceedings are also being recorded. If you have technical problems, please use the contact information shared in the chat to alert MAPC staff in the hearing, and someone will assist you. Our panelists tonight include the appellant, Mr. Sinani, Newton Preservation Planner, Barbara Kurtz, Newton Solicitor, Andrew Lee, as well as our review panel, who will introduce themselves in a moment. I ask that everyone on the panel keep themselves muted until it is their turn to present. Historic District Commissioners and others present in the audience will be promoted to be panelists when they are presented with questions from the review panel. When attendees are promoted to panelists, they will automatically be prompted to rejoin the meeting and be able to turn on their video and unmute. Any participant who is disruptive to the proceedings will be immediately removed from the hearing and will not be able to rejoin. Finally, in the event that the hearing is disturbed by Zoom bombing, it will be immediately terminated and a new date will be provided by public. MAPC is convening this hearing at the request of Mr. Mario Sinani. MAPC's role as a convener of this review is authorized by Chapter 40C, Section 12 MGL, and Section 22-40F13 of the Newton Historic Districts Ordinance, which designates MAPC as the appeal body for any decision of the Historic District Commission. This option is available to any community which so designates the regional planning agency as the initial appeal body. State law, Mass General Law, Chapter 40C, Section 12, provides that a city or town may provide in its ordinance or bylaw for a review procedure whereby any person aggrieved by such determination with the city or town clerk file a written request with the commission for a review by a person or persons of competence and experience in such matters designated by the regional planning agency of which the city or town is a member. The finding of the person or persons making such review shall be filed with the city or town clerk within 45 days after the request and shall be binding on the applicant and the commission unless a further appeal is sought in the Superior Court. This hearing was advertised in a local newspaper last Wednesday. As we are conducting this hearing virtually, we do not have a sign-in sheet. Please be sure to sign into the meeting using the chat by listing your name, affiliation, and address. At this time, I would ask everyone attending the webinar to introduce yourself in the chat. If you are a member of the Historic District Commission, please identify yourself as such. It has been MAPC's practice to convene these appeals as relatively informal public hearings using a volunteer panel of experts. Tonight's hearing will be conducted in a webinar format to limit potential for disruption. The hearing will begin with a presentation by the appellant, during which time panelists may ask questions of the appellant. Next, equal time will be allowed for a presentation by Newton City Solicitor Andrew Lee. During this time, panelists may present questions to members of the Historic District Commission, and they will be promoted to be panelists so that they may respond. Then the appellant will be given an opportunity to respond to the city's presentation. Public comments received in writing have been presented to the panel for their consideration. Depending on the amount of time the panel needs to make their decision, we will close the hearing with the panel rendering their decision. The decision will be written up, reviewed by the panel, and filed with the town clerk. Now I would like to turn the meeting over to our panel chair, Joel Bard, who will start by introducing the members of the panel and ask each of the panelists to say a few words about their background in historic preservation. Then he will go over the standard of review for these hearings and open the proceedings. Thank you, Joel.
Thank you, Anis.
So let me first introduce Marilyn Fenolosa, who will introduce herself and then pass it on.
Thank you. Excuse me, my name is Marilyn Penalosa. I am a retired attorney. I have a law degree from New York University. I also have a master's in historic preservation from Boston University. Previously, I was regional counsel for the National Trust for Historic Preservation Northeast Office. I currently serve as chair of the Lexington Historical Commission, and I served on the Historic Districts Commission, a separate group, for 10 years. So that's who I am.
Marilyn. Charlie?
Yes, I'm Charles Sullivan. I'm Executive Director of the Cambridge Historical Commission. I trained as a city planner, worked in historic preservation since the early 1970s. I've been director of the Cambridge Historical Commission since 1974, and appointed member of the Massachusetts Historical Commission since 1988.
Thank you, Charlie. So I'm Joel Bard. I'm a practicing attorney, so I get to chair these panels. We have been doing these panels as volunteers, particularly Charlie and I, for approximately 30 years around various communities in the MAPC district. And for those of you who aren't aware of the size of the district, it's 101 cities and towns in Eastern Massachusetts. My own background is as a municipal law attorney. I practiced with the firm KP Law, formerly Copeland and Page. And I practice in all areas of municipal law, but particularly focused on land use, environmental law, and of course, historic preservation. So we're happy to be here with you tonight. And as to the standard of review, we follow the case law for reviews of historic district commission decisions, which is to say, which by the way, defer to the practice for reviewing decisions of zoning boards, whether it's zoning boards of appeals, planning boards, but decisions made under the Zoning Act, Chapter 40A. This, as Anna said earlier, is under Chapter 40C, but the courts have looked to the procedures under the Zoning Act. And the procedure calls for the panel, namely the three of us, to make our own independent findings of fact. So we're going to hear the evidence as proposed, as presented, I should say, by the participants. Based on that, we are allowed to make our own factual findings. Once we've made those findings, though, we look at the decision of the Historic District Commission and we defer to that decision where we find that decision to be reasonable and not arbitrary and capricious and not contrary to law. However, if we should find facts different from the commission's findings of facts, then we certainly have the ability to make decisions based on that. So thank you, and look forward to hearing from the participants. I guess next we'll hear from the appellant, Mr. Sinani.
Excellent. Can you guys hear me?
Yes.
Great. My name is Mario Sinani, and with me today I have my brother,
Gerhard Sinani.
Give me 1 second while I share my screen. So I've made a presentation to make this as easy as possible. And of course, at any time, if there's any questions, I'm not sure if I can see a hand being raised, but I'm assuming the mic will be unmuted. Is that okay? I'm going to assume that's okay. Okay, let me. All right, excellent. So today we're here with regards to the appeal of a denial of certificate of appropriateness by the Newton Upper Falls Historical District Commission on my residence. I am the owner, Mario Sinani, at 959 Chestnut Street in Newton, Mass. Today's agenda will be touching base onto 3 topics. The first topic will be the height of the building, the main historic building, violations which are not visible from a public view or a body of water, we'll share some pictures and we will see the determination with regards to that, as well as City of Newton neglecting to provide documents per city ordinances. So this will be the 3 agendas. We'll start with the building height. I, Mario Sinani, hereby appeal by an adverse decision of the Newton Upper Falls Historical District Commission at its meeting held in February 11th, 2021, denying my application for a certificate of appropriateness to review height of the new constructed main house and application submitted on January 27th, Exhibit A. This is the application where it touches base on basement windows, window garage, freeze board, garage light, rear house grade, house height, retainer wall, fence color. So these are the items of the application. And as you can see, it was dated on 1/27th. Although the meeting was held in February, we have to provide content prior. On February 18th, it was noted that there was a denial on the basis that the building height was determined to be in violation at the February 11th meeting. So the Newton Upper Falls Historical District made a decision that indicated that the building height is different. With regards to the additional documentation that is provided, it is also indicated in here that they determined that there is an existing violation regarding the building height. The as-built main house block structure is in violation because it is taller than the historic structure that was approved in a certificate issued in September 10th to rebuild the main house. I think it's very important to note that approved original documentation did not specify height or request height or require height of any height measurements. Therefore, height was never approved in September 10th, 2020. So this is with regards to the comment made on this date. I will show the documentation that was presented to the Newton Upper Falls Historical District, as well as the Newton Inspectional Services. This is essentially the building plan. And in the building plan, all we have is the framing, first floor and second floor, as well as some work with regards to interior flooring of how we would salvage the existing rock foundation with some comments. And I have more pictures and more content that we can share and zoom in on all of this. So again, no height calculations were requested or submitted. These documentation can also be viewed in the Newton website, which has all the building applications there. Additionally, we'd like to note that height calculations for the rear addition were submitted on July 8th, 2020. They were submitted to ISD, which is the Inspectional Services. So it is a requirement for the Inspectional Services to have height documentation. However, for Newton Upper Falls Historical District, they have never requested any height documentation. With regards to this, it's very important to note that we will be using the documentation supplied in July 8th of the height. It's the only documentation of the height. And the reason for this is that the rear addition and the main historic home would have the same peak. As you can see in here, they would meet at the same peak. Therefore, the proposed peak elevation of whether it's the main house or the addition will be at 164.47 feet. That is, again, a measurement that is done from a land. It's not that it will be 165 feet from the ground. You can see in here essentially the height of the building, which is measured by these calculations. So this is a requirement by the City of Newton when they indicate what height is and what is all the documentation they were needed. And it's a requirement that can only be done by a land surveyor, so a professional land surveyor. Newton Upper Falls denied applicants with prejudice on the basis that the new constructed house is taller than the historic structure and what was approved, based on visual appearance and not based on certified surveyor measurement calculation. This is not consistent with the provision of City of Newton Historic Preservation Design Guidelines and is not in compliance with the request made to Inspectional Service Department to confirm the height of the existing building compared to what was approved by hiring a licensed surveyor to determine these calculations and to determine the existing grade to the site, and further request that ISD do an instrumented survey to verify the height of the ridge and the floor heights and the grades around the building, and that ISD conducts enforcement for all violations in due time. This is Exhibit B. So it's very important to note that the Newton Upper Falls Historical District indicated back in December 15 that they would like to send the notice of violation to Inspectional Services, which is ISD, for enforcement action and request that ISD confirm the height of the existing building compared to what was approved by hiring a licensed surveyor to determine the calculations and to determine the existing grade of the site, and further request that ISD do an instrumental survey to verify the height of the ridges and the floor heights and the grades around the building. And most importantly, and that ISD conducts enforcements for all violations in due time. I want to note, which is something very important, that ISD placed a work stop order on December 18th, 2020, violating city ordinances as well as Newton Upper Falls request, as no height was measured prior to December 18, 2020, as you can see from their own documentation, placing a work stop order under no actual proof of any height violation. They simply stopped my work for 0 reasons. We would like MAPC reviews Newton Upper Falls decisions for the reasons set forth, and we hereby respectfully request that MAPC reverses the decision of the Newton Upper Falls Historical District and approve the application. Owner's application should be approved because the instrumented survey was not used to determine the height of the new constructed house. The new constructed main house is consistent with the provision of the City of Newton design guidelines and will not have an adverse effect on the historical character of the district or property. Owner's application should be approved on all items within the application, since no application review occurred per Chapter 22-40 F4 within the required time frame. Experts attached as Exhibit C. So the Newton Upper Falls has 45 days to make a determination when a resident provides an application to them. And it stated it, a commission shall render a decision within 45 days after the filing of a completed application for a certificate of appropriateness, unless further time is allowed in writing or by the applicant. If the commission shall fail to make a determination within 45 days, the commission shall therefore issue a certificate of hardship. It's important to note that the violation was made based on no actual facts. Therefore, trying to deny an application for no facts, therefore, the application was submitted in January and we're in June. It's taken them over 6 months. Additionally, items were not reviewed and denied based on the determination of a height violation, decided without following their own request to conduct an instrumental survey to determine house height in comparison with the original application survey calculation building height. So again, Newton Upper Falls Circle District a month before requested for ISD to perform the survey, and a month later, they decided to ignore that data and they decided to place the house under a violation without any actual documentation. And this is Exhibit D. This is essentially the height survey that should have been used. This is from my surveyor, and the City of Newton would have made the same surveyor on their end. Newton Upper Falls decision to deny an application seeking a certificate of appropriateness for certain proposed improvements on my lot was on its face not based on legally tenable ground, where the decision relied on criteria not found in the relevant enabling act or by law, consisted of mere repetition of statutory language, and failed to link any alleged harm to a relevant statutory factor. Newton Upper Falls has never approved or denied height or grade at the new constructed main house. This is Exhibit E. We will show in here, this is the full application of the house. And as you can see, contains many signatures, one of them being the Newton Upper Falls Historic District. And on the site plan, we can see that there is 0 grading shown. Therefore, any violation that is claimed for grading makes no sense, because grading was never approved or was never told us that we had to provide grading to them. Additionally, no height was ever provided. So it's very important to note that no grading or height was approved as shown on the actual approved building application. Upon Newton Upper Falls project approval, the applicant, I, followed the City of Newton Ordinances, Volume 2, Section 1.5.4, and submitted to ISD documentation signed by a surveyor prior to the building permit approval, which notes height of the proposed house. Again, this is Exhibit D, which we showed here. So again, this document was provided to ISD. The process works. You first have to get approved by Newton Upper Falls Historical District. Then you apply to ISD. ISD requires documentation. This is the height documentation that was supplied to ISD, but it was never requested previously by the Newton Upper Falls Historical District. Not only did the Newton Upper Falls not approve or deny height or grade, but they also did not review the appropriate documentation that are required by the City of Newton ordinances and made the determination based on visuals from previous photos, counting only siding and not the full height of the building. Exhibit F, I think we're going to spend a little bit of time, and this is very important. So based on the Newton Upper Falls decision, they indicated that the height is only counted by the siding. However, they forgot to count the full height of the building, because the building can be counted just by siding. It's a building. And it's very important to note here a couple of things. So I'm going to try to zoom in, and I've made these red lines. What they do is they're a count of 10 siding. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. They keep going, and we can always confirm this if we want to, but due to time, I don't think it's necessary. I've been able to count 64 sidings instead of the 63 as indicated by the Newton Upper Falls Historical District. As noted by the Newton Upper Falls Historical District, each of this siding is at 4 inches. If we take 64 times 4 inches, we get 256 inches only on the siding. Now, what's important to note is that the top of the vinyl, on the top, there's molding in here. That molding height is at 17 inches. Additionally, what's important and was missed or was not counted on purpose by the Newton Upper Falls Historical District is the rest of the height, which is the retainer walls. As you can see in here, there is 5 blocks, 1, 2, 3, 4, 5, as well as a cap. Each one of those blocks is at 8 inches and the cap is 3 inches. If we take these equations, they equal to 43 inches. So if we were to add 256 inches, which is the vinyl, and we were to add the molding, and we were to add the retainer wall here, we get a total of 316 inches, or 26 feet and 4 inches from ground. Now, again, I want to show another picture just to show that this is not just a wall that is placed in there. And this is a very old picture where we can see that the bottom part of the house was essentially had a retainer wall around it, covering that area. And what's also important to note is that the fence was never removed. This is a fence that has been in the property for decades. And we can actually kind of guide ourselves and see that it is true that the retainer wall was there. And with regards to the location of the fence, we can actually have a visual idea of the retainer wall. Now, per ISD requirements, so now I'm going to take it to the other side of the house. So what we just saw was this end as essentially the side yard to the left, and this is to the right side. Per ISD requirements, we had to install a full drainage system where the full driveway was removed and pitched to collect water at the garage by the trench drain. Driveway used to be higher than sidewalk, and this is visually, we can see that this is the street, this is a sidewalk, and there is a bump on the driveway. It's important to note, though, that the whole driveway had to be completely ripped off so that we could install a drainage system designed for a 100-year storm event. And additionally, to indicate that the driveway is completely new, the driveway is also pitched. And the reason why it's pitched, it's done that so that all the water can be collected on the trench drain. So we don't want the driveway to be higher because then the water will enter the street. And the reason for this is to avoid any liquid that enters essentially my property should all be retained on those huge chambers that were installed. And this is the trench drain, where it's essentially, think of it as the lowest point where all the water goes. Again, I just want to show that the trench drain, it's a pretty long trench drain. It goes throughout the whole garage door. For ISD requirements, we had to install a full drainage system where the full driveway was removed and pitched to collect water at the garage by the trench drain, resulting in the driveway being lowered than before. So it's very important to note that the driveway before used to go up at this end, and now it's going down. This is the reason why height is measured from a benchmark, like the back of the sideway, and not counting siding. So again, this is more of a rule that every, I would say, city uses. They use the sidewalk as a value, as a number. They cannot go by counting siding because during construction, all the land around gets removed, as you may need to do a basement or whatever that may be. In addition, per Chapter 2240 G6, Newton Upper Falls shall not review and shall issue a certificate of non-applicability for the reconstruction substantially similar in exterior design of a building, structure, or exterior feature damaged or destroyed by fire, storm, and other disasters, provided such reconstruction is begun within 1 year. So this is a law that states if your architectural features, exterior architectural features are damaged, you shall receive a certificate of non-applicability. Very important, this is the law. And I will show this law, this Exhibit G. A commission shall not review and shall issue a certificate of non-applicability for the reconstruction substantially similar in exterior design of a building, structure, or exterior architectural features damaged or destroyed by fire, storm, and other disasters, provided that the reconstruction begins within 1 year. Very important to note that the commission did not provide us the non-applicability certificate. Instead of following the law, they enforced that we apply and not receive the certificate of non-applicability as per law. The house was damaged, all the exterior features were damaged because the house collapsed. And this is an email written on the same day of the collapse, hours later, indicating that we need to send an email requesting to be added to the agenda for the September 10th meeting. The word other disaster is defined as sudden or event bringing great danger, loss, or destruction. And we use the former dictionary Merriam-Webster. not only that we can use destruction, but architectural features were damaged as well. So it's either or. Newton Upper Falls delayed sharing with the property owner the height calculations performed by the City of Newton surveyor on December 22nd, 2020, and keeping the house under a work stop order for 6 months, knowing that there is no height issue. Exhibit H. This is documentation done by the City of Newton surveyor engineering department. It's very important to note here that the work stop order was intentionally not lifted even after the City of Newton surveyor calculations show that the main house block is as proposed. What they did is they have many counts of each ridge, essentially the pitch of the highest point of the roof. And I'm going to use one count here that is circled. This is the right side front of house at the gable side, and from rough ground to roof peak, we can see a measurement of 26.4 from rough ground construction site. December 22nd, 2020 was the first time the city measured the property, and the work stop order was placed on December 18th, violating Newton as well as state laws. House currently is still on a work stop order as of today, June 14th, 2021. It's 6 months. Now, the reason why I'm saying that it was never supplied to us is because we asked for this document since December 22nd, because we allowed the city to enter our property and measure the height. And I want to show the first email where this document was shared with us. As you can see, the date is April 15th, 2021. So it's indicated I've received the exhibits, and I'm also attaching plus the memo. Actual height measurements from the City of Newton were provided after 4 months. They kept the height calculations after 4 months. It's also important to note that this is after the house was deemed to be in violation. It was deemed to be in violation in February. They measured them in December. They didn't use them. On February, they made the house in violation. And then on April 15, they decided to provide the documentation. These calculations were requested by Newton Upper Falls and were never shared with the property owner or in the Newton Upper Falls Historical District Commission because they showed that the height of the main building is as proposed. Calculations were performed on December 22nd and were shared on April 15th after over 50 emails and phone calls to request the actual measurements from the City of Newton as well as the height was placed into violation and after the appeal of MAPC, April 15. Using Newton's own GIS topography, we can see the grade of the main house block on the left side of the side yard in the center being at 138. So I'm going to show now Newton's own data. This is Exhibit I. So this source is essentially a Newton website where provides you a topography of the land that is around Newton. And in here, as we can see, is just to provide some quick knowledge. These red lines are for every 10 foot and the yellow lines are for every 1 foot. And in here, we can see that in the center of the side yard, we are at 138. The way we do that is 140. We go down to 139, 138, and we track this, and it's right in the center. And additionally, we can also confirm that the fence was never touched. So that means that this area should still be at 138, okay? So fence was not touched, and we can see the same grade. So using Newton's own data, we now have the surveyor engineer's calculation, which was at 26.4, plus or minus a 1.5 feet almost. We'll also use the height taken from the Newton GIS, which is 138, and we'll do a quick calculation. So this is what should have done, right? So they would have known where the grade is. Then they used the measurement from their engineer, which was done a few days after the house was placed in violation. And if we had 138 plus 26.4, we get 164.4 plus or minus 1.4 as indicated here. But we won't even use the plus or minus. So we'll go to Exhibit J. Exhibit J confirms that using Newton's own data, the corner of the house is at 138 plus 26.4, we get the exact proposed roof peak elevation at 164.4. Using Newton's own data on December 22nd, we can confirm there's zero height violation. City of Newton Deputy Commissioner Anthony Ciccarello requested that a interior height measurement is measured by the owner surveyor of the as-built main house, which was shared on February 22nd, 2021, days after the Newton Upper Falls had already placed a height violation, which was on February 18th. We'll show exhibit. This is Anthony Ciccarello, he's the Deputy Commissioner. He's checking in and asking if I had my surveyor do the calculations of the first floor elevation, second floor elevation, attic floor, and roof peak. Again, these are all interior measurements. Very important to note that. Surveyor mentioned that this request is unique as this is not a requirement per Newton or state law. However, surveyor performed the interior measurements as requested by the City of Newton. The main house block interior height from the surveyor shows a height of 24.7 from the first floor to the roof peak. So this is the request, and the surveyor provided the interior as built. As you can see all the floors. You can see the second floor, the attic, and the roof. And from the first floor, we have a height of 24 feet and 7 inches. 24 feet, 7 inches. Per Newton state law, when building a new structure, the applicant must submit height calculations from a registered land surveyor, Exhibit M. So again, we want to show the law that indicates that if you want to build a new one, you have to provide height calculations, and the height calculations need to be surveyor by registered land surveyor stamped. Okay. Only a surveyor can provide height calculations. No one else, not me, no one else. Per Newton law, rules of measurements show step-by-step of height calculations, rule law, Exhibit N. So this is taken from the Newton City Ordinances, Chapter 30. And if we go to height, the way that height is defined is the vertical distance between the elevations of the average grade plane and the highest point to the roof. Not including such measurements are a couple of bullet points in here, but at least we have an idea of what height is and what height is defined. Benchmark measurement of height is back of sidewalk, highest point. We can then measure the height of the property at a different angle or right side using the benchmark point as well as the interior height calculations, Exhibit O. Additional calculations on the other side of the house show that the building is exactly as proposed. So very important, Exhibit O. We have interior height calculation of the first floor. We also have the roof peak as well as the back of the sidewalk. And again, this is the Newton GIS, so we can kind of get an idea of where we are. This is the highest point of the back of the sidewalk, and we're gonna do a measurement that it's here. And in here, not only that we can confirm in here that this grade goes down, but we can also visually that the grade goes down. So if we look at the back of the sidewalk, is this piece of wood right here, and this is the highest point of the back of the sidewalk, which is essentially the point at 140.33. Okay, this right here is 140 back of the sidewalk. Benchmark from the grade plane calculation submitted by a certified surveyor, and he's the only one who can provide this content. Then if we look at the top of the first floor elevation, we can see that the top first floor elevation is lower than the benchmark. And it's actually exactly 6 inches lowered. And these are straight lines, which show that the first floor is lower than the benchmark. So if we were to take the first floor elevation, we know that we are at 139.83, which is a difference of 6 inches subtracted from the bench of the sidewalk. Okay, and we know that the height of the first floor to the roof peak, as provided by the surveyor, was 24 feet and 7 inches. So what we do is we convert the 24 feet and 7 inches into decimals, which ends up being 24.58. So the way it's done is 1 divided by 12 inches, and you get 0.083 per inch. The back of the sidewalk is higher than the first floor elevation because that is at 140.33. First floor elevation is at 139.83. Height of the first floor to the roof peak, which is by a surveyor, is 24.58. So now let's take these measurements. Let's take 139.83, which is the first floor, plus the height from the first floor to the peak. We get exactly 164.4. This is the same value as the documentation that were provided last year by the certified surveyor, 164.4. Again, take your time and do this calculation. 139.83 plus 24.58, 164.4. Again, showing another angle that the house, it's impossible to be in a height violation. Now I'm going to show another picture, which shows the first floor, as you can see here, and we can also see the difference where the back of the sidewalk goes higher. So visually, I want to show not only actual documentation, but also visually to see that the back of the sidewalk is 140.33. It's higher than the first floor elevation. Another interesting factor is that when we provided this documentation to Anthony Ciccarello, who is the person who reviews all these documentation and approves the permit, he indicated that after the review, the height, they are waiting for the Newton Upper Falls to move forward. So I asked the deputy commissioner for the status and indicated that they're waiting for Newton Upper Falls then to move forward. If there was a height issue, ISD would never know that they're waiting for the Newton Upper Falls Historical District. In fact, this is their responsibility, and they would immediately say that you have to fix this. But they know that there is nothing wrong because they have their documentation, they have my surveyor's documentation, and they have looked at it, and that they know that there is no height issue. The main house block collapsed on August 19th, 2020. On March 26th, 2019, professional engineer Richard A. Vulcan wrote a structural report of the property and sent it to John Logic, City of Newton Commissioner, and Newton Upper Falls Historical District, stating the significant structural failure of this property and deemed the property not suitable for habitation. Newton Upper Falls went against the professional engineer advice and placed my life at harm, knowing that this property was in extreme structural failure. I will show the exhibit. This is Exhibit P, where the inspector, this is a professional engineer, performed a structural inspection, and it is indicated at the end, it is my professional opinion after the inspection of 959, is in significant structural failure and is not suitable for habitation. Repair attempts would be so significant, complete structural failure could occur. And that's exactly what occurred. When the main house block collapsed, I was present at the site and almost died from the structural failure, all because Newton Upper Falls Historical District went against a professional engineer advice. Risking residents' life is something that the City of Newton should prioritize. When the structure collapsed, I immediately called OSHA. OSHA came to the site and they did not find me as a property owner or the contractor at fault and indicated that Newton Upper Falls and the City of Newton should have never gone against the professional engineer risk assessment. When the main house block collapsed, the top layer of the rock foundation crumbled. Newton Upper Falls recommended to utilize the existing rock foundation due to the historic feature, Exhibit Q. As you can see in here, even on this picture, this is the main historic, this is the rear addition. We can actually see the rock foundation, huge rocks that essentially disassembled from the basement. Newton Upper Falls approved to rebuild the main house block under the condition to reinforce the existing foundation as detailed in the drawings. This is R. This is again from City of Newton. To reinforce the existing foundation as detailed in the drawing and to rough frame the floors, walls, including installation of roof, with the requirement that the dimensions will be reproduced exactly as they were, including the footprint and building height. Additional pictures provide proof of how the existing foundation was reinforced based on the Newton Upper Falls approval. So this is what was approved. And as you can see, it's very important to read all this, is that existing fieldstone foundation to remain. So we couldn't pick up the rocks and put them on top because we couldn't touch it. And installed fieldstone concrete cap of 2 inches. So we had to use whatever level was there, install a 2-inch cap, and the whole floor is actually being held inside by underpinning. So it's a good picture which shows pre-collapse, the house, the height measurement calculations, the back of the sidewalk at 140.33. We've taken the same house because we're supposed to build with the same footprint and showing the new house. Now, knowing that the first layers of the rock foundation crumbled, knowing that we only had to use what was the existing rock foundation, we can see that there is an interior drop, but it's only an interior drop, has nothing to do with the building height. That's just a visual that I made to show. It is important to note that the memo written by John Logic on March 4th uses a mix of measurements from outside and inside the house, which results in a confusion with regards to the building height, and it is not accurate. Exhibit U. I'll show some T's again, but we'll do Exhibit U. This is the memo from John Logic written on March 4th. And I do want to show the previous floor. So this is the rear addition. And as you can see, it's much lowered. And this used to be the initial first floor. And as you can see, this was the rock foundation that all collapsed. Now, once you see it here, you can see that the addition and the first floor are at the same level now, because we had to keep the existing rock foundation. So we can see that this was a drop interior. It's very important to note that the Exhibit U, which I just shared of John Logic, it does not comply with city ordinances and regulations. It is also very, very important to note that the memo was written after Newton Upper Falls Circle District placed a height violation. After I had requested an appeal to MAPC, the memo was drafted to protect the Newton Upper Falls Historical District. Newton Upper Falls Historic District Commission requested a city official to write a memo in their favor, is completely biased, and shows how I'm being treated in this process. Exhibit U. As you can see, March 4th, this letter was written. Should have been written in December. Per memo, it is indicated that the house height is bigger than 3 feet, which is impossible and shows how the house would look, Exhibit V. So if we take our house now and go by the memo, which is incorrect because it's a mix of interior and exterior height, we can see what the house should look like. And what we have done is these sheathing are 4 by 8. So if we were to take this and go in half, which is this line, it's 2 feet. If we go in here, that's 3 feet, and that's 3.16, which is the claim on their end. So what I've done is I've taken this aspect and I've lowered this, lowered by 3 feet. As you can see, this is the top where I'm seeing here, and lowered it right there on the line that you see here. So this is the claim of what the house should look like by the Newton Upper Falls Historical District. This is the house in early 2000. This is what it is right now. This is what they want it to look like. Additionally, Commission shall not consider interior arrangements or architectural features per Newton City ordinances. Newton Upper Falls using a rendering of interior floor from an architectural drawing as height does not comply with Newton ordinances, Massachusetts Building Code. Architectural drawings show architectural visual fixtures effects and are not stamped by a surveyor, which is a requirement for height measurements in the city of Newton. The rendering is used as a proposal of where interior floors could be located. However, per Mass State Building Code 780 CRM and city ordinances, all interior modifications are subject to change without any approval from Newton Upper Falls Historical District. It's very important to note, what I do inside my house, I do not need the approval of the Newton Upper Falls Historical District. As an example, if I want to have cathedral ceilings, I can do that. I don't need their approval. Okay. So if my height now is 8 feet and I remove the ceiling and I want to have a cathedral, so now it's 15 feet, they can't come to me and say, well, remove your whole roof and lower it so that with the cathedral, you're now at a peak of 8 feet interior. No such thing. Additionally, audio recordings from the Newton Upper Falls Historical Meeting show a different procedure used when handling my property, Exhibit X. I've been dealing with different procedures for the last 2 years, and I'm going to play a video of what regular residents or
sidewalks along Oak Street, certificate at 1214-1220 Chestnut Street, certificate of appropriateness. There's someone to speak on that?
So that sounds, pretty typical. I know that the panel are in chair, or they've also worked in historical districts, and the chair asks for the applicant to present their application. Now let's hear what.
Okay. It's 959 Chestnut Street, and the way we are going to handle this case is a little different. We are going to.
Why do I get treated differently?
Sidewalks along Oak Street.
Keep that in mind, please.
Certificate at 1214-1220 Chestnut Street. Sidewalk.
Owner stop work order should be lifted since the Newton Upper Falls Historical District has implemented a work stop order on the project without any code violations. There is 0 code violations in this property. We have built exactly what was approved by the Newton ISD. Newton Upper Falls enforcing ISD to place a work stop order on a project violates City Ordinances Chapter 22. For Chapter 2241J, Newton Upper Falls does not have jurisdiction to enforce ISD to place a work stop order on the project during an ongoing construction without any building code violation. Okay, I'm going to reference to the why. So this is the reason why I was placed under a work stop order. But again, I want to read, which is very important. The commission shall notify the Commissioner of Inspection Services of building official in writing of any violation of the requirements of his ordinances or his determinations, rules, and regulations with regards to a specified building or structure, and shall instruct said commissioner or building official to make a permanent record of such violation in the corresponding property file maintained in the Department of Special Services as required by law. Prior to the issuance of any building permit, prior to the issuance of any building permit of the construction, reconstruction, alternation, renovation, repair, removal, demolition, or change of use of occupancy of any building or structure, said commissioner or building official shall review the property file and ascertain whether a notice of unremediation violation on this ordinance is on record. Again, prior, I already have a building permit. I was stopped in the middle of a building permit.
Mr. Sinani, I'm reluctant to interrupt you, but I noticed you're spending a lot of time on what you consider procedural irregularities, and we're not going to be ruling on that. I think it'll be more efficient if you spend less time on those kinds of issues. Certainly, all of the data about height and how you measure and so forth, it's all very pertinent, but I think it will help everybody if you spend less time on the procedural issues, which we're not going to act on anyway. We're really concerned looking at, you know, the fundamental.
Okay, understood. I'll make sure of that.
Thank you.
Thank you. So for the reasons set above, Newton Upper Falls failed to review certified surveyor measurements calculations, as well as their request to ISD to hire a certificate surveyor to perform height measurements in comparisons with owner's submitted documents. In addition, owner's proposed application will not have an adverse effect on the historic character of the district or the property. It's consistent with the provision of the City of Newton design guidelines and is in consistence with the Massachusetts State Building Code 780 CRM. So that is the height. Now we'd like to focus on the additional violations that were indicated as violations, but I think it's important to note that most of these violations are not visible. So Newton Upper Falls placed multiple violations on items which are not visible from a public way or a body of water, violating city ordinance claiming invisible items to be visible. So this is Z. These are all the claims by the Newton Upper Falls City of Newton, where they've indicated that the basement windows and exposed foundation area is in violation. The window program on the left side of the garage is in violation. The new retainer walls, the space between the top of the window molding and the freeze board and the main house block, the location of the garage light and the drop garage floor, the grade changes and the exposed basement wall, exterior walls, stairs, and windows on the rear gable and elevation, as well as vent pipes and location of electrical panel. Attached are photos taken from eye view of actual public view at the property on both Chestnut Street as well as Ellis Street. I want to show some pictures of what's visible from a public view. And on the side, I'm not going to repeat all of this, but clearly we cannot see any basement windows or exposed foundation, no window program on the left side garage, no retainer walls, no grade changes or exposed basement walls, no exterior walls or stairs can be seen, no windows on the rear gable, no vents and pipes. And I'm just gonna scroll through coming down on Chestnut Street. And if at any point you do see any of these, I can always look at these pictures back. And the property here is this property right here, which you cannot see much on the back. For visibility from a public view or a body of water, in fact, there are two visible items: the space between the top of the window molding and the frieze on the main house block, as well as the location of the garage light. The space between the top of the window molding and the frieze board of the main house block, it was approved by the Newton Upper Falls to be 8 inches. Exhibit AB, this is the property where they looked and everything is covered in vinyl. So you couldn't see any moldings at all. This house had lost its historic values of molding. And what was decided based on visuals that the frieze should be 8 inches. After the siding was removed, the frieze board was 10 inches. However, we installed what was approved by the Newton Upper Falls Historical District. The location of the garage lights are approved are 24 inches in height. If we did not place the location of the garage lights higher, then they would hit the garage door molding, and this is not standard practice. Exhibit AC. So in here, we can see where the location of the garage lights are. This is the actual lights being at 24 inches where they would fall. And if lowered based on the approval that was done initially, we can see that not only does it hit the molding, but also could hit a vehicle as it enters the garage door. So I do agree with this, that I will need to file an amendment to raise the garage lights. Of course, the garage lights are not historic and will not have an adverse effect on the historical character of the district or the property. Newton Ordinances 2240 G3, a commission shall not consider interior arrangements or architectural features not subject to public view. The word public view is defined as an area that can be readily seen and that a person within the area can be distinguished by normal unaided vision when viewing from a public view. This is AD. Again, this is, so I'm going to skip this because we just spoke about that. Per Newton ordinance, a practice of every resident in Newton, permanent fences are structures and they require a building permit and the historical district approval. Newton ordinances do not claim that permanent fences do not act as a visual barrier. Commission indicated that we would practice other cities' ordinances. And when I asked to have this in writing, they refused and said that I have the option to appeal. My property is located in Newton and not in other cities. Additionally, if we were to entertain this idea, we can observe the Brookline ordinances and see that only new fences will not act as a visual barrier. My fence has been installed decades ago and is not new. So again, if we were to look at another city's ordinances, we can see new fences should not act as a visual barrier, only new fences. Owner's application should be approved on all other items within the application since no application review occurred per 2240F within the required time frame of 45 days. Items were not reviewed and denied based on a determination of a height violation, decided without following their own Newton Upper Falls Historical District request to conduct instrumental survey and to determine house height in comparison with the original application survey calculations, building height. AF, would like to show exhibit AF. A commission, again, shall not review and shall issue a certificate of non-applicability for the reasons where exterior architectural features are damaged. Newton Upper Falls decision in denying owner's application seeking for a certificate of appropriate for certain proposed improvements on my lot was on its face not based on a legal tenable ground, where the decision relied on criteria not found in the relevant enabling act or bylaw, consisting of mere repertory statutory language and failed to link any alleged harm to the relevant statutory factor. Not visible items. This is AG. I will not focus on that. I will only bring that up on when there is questions, because what is being claimed as violations are not visible from a public way. So City of Newton neglecting to provide documentation per city ordinances. As elaborated above, there have been many instances where the commission has gone against city ordinances and not provide documentation per law, only retaining to owner Mario Sinani. This is extremely concerning as no one is above the law. Newton Upper Falls Circle District required to reapply for certificate of appropriateness for exterior items, which is inconsistent with city ordinances that were previously approved with the original application. There should be no reason to reapply for already approved items. Exhibit AH, almost done, sorry. We can see that I was made to apply for an application that says, I am rebuilding the main historic block due to collapse from structural failure during construction of rear addition. I will rebuild the main historic block with the same material and style that was previously approved by the Historic Commission. I'm being asked to reapprove everything for 0 reasons. Owner's application with regards to the main house block has not yet been provided certificate of hardship per law 2240 F4, where the commission failed to make a determination within 45 days. AI. Additionally, application was denied by placing an invisible item in violation and claim it is visible when it's not. So again, a commission shall not review and shall issue a certificate of course. Oh, that's AI. So the Application was done on September 2nd, and it was denied on November 12th. Okay? Retainer walls are not visible from a public way, and this is another example of denying items for absolutely no reason and putting not visible items in violation, going against city ordinances. Decision made took 71 days after applying. Law states that after 45 days, I need to receive a certificate of appropriateness, and I'm still waiting for that certificate of appropriateness. That is all I had. Thank you everyone for listening to my very long presentation.
Thank you, Mr. Sinani. That was very helpful. And now I believe we're going to hear from Attorney Lee. Is that correct?
Yes, thank you, Mr. Chair. 1 second. Okay, can everybody see that?
Yes. Okay.
As stated, my name is Andrew Lee. I'm an assistant city solicitor for the city of Newton. I'm representing the NUF HDC in this matter, the Upper Falls Historic District Commission, who I'll be referring to as the HDC throughout my presentation. I'll also be referring to Mr. Sinani as the owner. Now, with regards to exactly what is on appeal, it's important to note that there are just two decisions from the February 11, 2021 HDC meeting that is before the panel tonight. Both of these decisions have to do with existing violations at the property, violations for construction of exterior architectural features that were done either without HDC approval and review, or items that were constructed in a manner that substantially deviated from previously approved certificates. I'm going to take each of these decisions in turn, starting with the first decision that has to do with the building height of the main house block. This is taken from the record of action from that February 11th decision regarding the building height, where the HDC determined that the main house block as built is in violation because it did not conform to the requirements of a previously issued certificate of appropriateness dated September 10th, 2020. Notwithstanding all the information you heard, the question regarding the decision of the main house block is actually very straightforward, and what is before the HDC is this simple question. They need to ask whether there are no grounds which a reasonable person might deem proper to support the determination that the as-built height of the main house block is higher than what was approved. The decision was a determination of an existing violation, a determination that a previously issued certificate of appropriateness was violated. So in order to understand exactly what the basis of the HDC's determination was, we have to look at what was the certificate that was previously issued, what did it permit, and also what circumstances gave rise to the need for that certificate in the first place. This is a picture of the building on the property prior to the owner's purchase of the premises. This is the building, the house that existed in the beginning of 2019. You see there's a red line in the image. Everything that's to the left of the red line is something that I'll be referring to as the rear addition of the property. Everything to the right that's facing the street is what I've referred to as the main house block, and I'll continue to do so. So originally, when the owner purchased the property, he came to the HDC with a request for a full demolition of the property and approval to rebuild a new structure that's taller than it existed at this time. And that request was ultimately denied. Shortly after, the owner actually came back to the HDC and then requested approval to preserve the main house block as we see it here, demolish the rear addition, and build a new rear addition. On October 11, 2019, the HDC issued a certificate of appropriateness authorizing the owner to replace the rear addition but preserve the main house block that we see here. Pursuant to that certificate, the owner proceeded to demolish the rear addition, and this is the image of the main house block with the rear addition removed. As the owner was remodeling the building, demolishing the rear addition as well as renovating the main house block, the main house block actually collapsed. And this was in August of 2020. The HTC viewed the property. They did an investigation, determined that it was not salvageable. It was a complete loss, and the historic structure couldn't be rebuilt with the original materials. They did ask Mr. Sinani to come back with a plan for how to rebuild the structure. And pursuant to that application, they made a determination on September 10th, 2020, issuing a certificate of appropriateness to Mr. Sinani to rebuild the main house structure, specifically with the requirement that the dimensions will be reproduced exactly as they were, including the footprint and building height. This September 10th, 2020 certificate is the one that's referenced in February 11, 2021 decision regarding the height of the main house block. This is the certificate that the HDC has determined has been violated because the main house block as built is taller than the main house block, the historic one that had collapsed. Mr. Sinani claims, or the owner claims, that the HDC relied only on visual appearance to make that determination that the main house block is in fact taller as built than what had the historic main house block that had collapsed. Although the HDC could tell from the visual interpretation that the as-built main house block was in fact taller, that's not all they relied on. They relied on photographs, plans that were actually submitted by the owner himself, testimony from witnesses, as well as calculations from ISD. What you can see here are a series of pictures of the main house block as it existed in 2019 and the main house block as it was rebuilt after the collapse. What you're seeing here in the first picture is the stage left view of the main house block as it existed in 2019. The second picture is the same view, but as built. You can see several discrepancies with regards to the features on the as built that do in fact make it clear it's taller. First of all, the distance from the ground to the bottom of the bottom windows, as well as the distance from the top of the lower windows to the top of the awning and the bottom of the top window. And lastly, the distance from the top of the top window to the roof are all greater in the as-built than they are in the historic house block. Similarly, if you look at the front picture, the front image of the main house block as it existed prior to the collapse, and then the as-built of the same view, you can see that the awning of the as-built is in fact wider, taller than existed previously in 2019. You can also see, it's hard to make out here, but there will be an image later on that makes it even more clear, that there's a larger gap in the as-built main house block from the top of the windows to the frieze board than existed in 2019. But as I mentioned, the HDC didn't simply rely on a visual interpretation of the height of the as-built main house block. They also had plans. Now, in October of 2019, when the HDC issued the certificate to preserve the main house block and for the owner to demolish and rebuild the rear addition, they required the owner to submit plans showing the main house block as it would be preserved, as well as the rear addition. These plans were approved by the HDC in October of 2019. You can see that the height, this is actually an image taken from those approved plans from 2019, and it's a front elevation view of the main house block as it existed in 2019, and it has a height calculation of the main house block prior to the collapse. You can see from the first floor to the top of the gable roof, it was calculated that the height was 21 feet, 10 and 3/4 inches. So this was the height of the main house block prior to the collapse. In the September 10, 2021, the September 10, 2020 certificate where the HDC authorized the owner to rebuild the main house block, they made it clear that the owner had to rebuild it to the exact same dimensions as the collapsed house block. And they explicitly called out the height. To say that the HDC didn't approve the height is patently false. Right here, they made it so that the height would have to be the same as it was prior to the collapse, which is 21 feet, 10 3/4 inches. Now, subsequently in January of 2021, the owner submitted as-built plans to the HDC that showed the structure as it was constructed. This again is an image of the front elevation taken from those plans. Again, we have the height measurement from the first floor to the top of the gable roof. The calculations here set the height as 24 feet and 10 inches. Again, this is what was approved, 21 feet, 10 3/4 inches. This is what was submitted as the as-built, 24 feet and 10 inches. Additionally, the owner did reference in his presentation that the HDC chair actually looked at this vinyl siding and then the green board that is currently on the as-built to determine what the height of the building is. The owner showed you an image from the stage right view of the structure, but that's misleading because even from the images that he showed, the grading on the right side of the building has been so substantially changed. It's almost impossible to see where it originally was. Therefore, all the images that I'm going to show for the main house block regarding the height are going to be from the left side. So on the left side, according to the chair, there are 64 rows of vinyl siding. Each row of the vinyl siding are 4 inches tall, which comes to a simple calculation of 252 inches, which is 21 feet. Taking into consideration the height of the rafters at the top to the gable peak, it is similar to exactly what was shown in the owner's submitted plans of a height of 21 feet and 10 3/4 inches prior to the collapse. This is the same view of the as-built structure from the left side. The chair, during deliberations in the HDC meeting, noted that each green board that is here is 4 feet in height, and you can count 6 green boards that are full to the top, equaling a height of 24 feet. There's also a partial portion of a green board at the very top. And of course, you need to account for the space in the rafters. Again, 24 feet plus that space also conforms with the as-built that was submitted by the owner himself that shows a height of 24 feet and 10 inches. Now, the owner would have us believe that the reason, the discrepancy in the height in the plans that he had actually submitted to the HDC is not because the building was built up, but because the building was somehow built down. However, these are images of the exact same portion on the left side of the building that show where the siding, where the exterior meets the basement floor, the portion that's exposed. As you can see from the images of the historic structure on the top and the as-built on the bottom, the amount of shown basement is identical. The location from the bottom to the ground is also identical. There's really no difference, and certainly not 3 feet of difference. More importantly, the owner's argument that states that they built down instead of up is somewhat nonsensical because the requirement in the certificate was that the dimensions of the main house block would be rebuilt exactly as it existed before the collapse. By saying that they built lower to make the main house block itself actually taller, if not taller, in ultimate height up to the sky, they still didn't build it to the dimensions of the collapsed main house block. Lastly, the owner has made several references with regards to plans that were submitted to ISD. Those aren't the items that were before the HDC. The HDC had their approved plans, which has been shown not only in this presentation, but in documents that were submitted to the panel. More importantly, ISD actually submitted their own memo to the HDC, and they didn't submit it to the HDC until March of 2021. However, they did the height calculations in February of 2021. And how they did that, they actually sent 2 inspectors, 2 of their own inspectors, out to the property to manually measure the height of the main house block. According to that measurement from the floor deck to the ridgeline, the peak, they came away with a measurement of 25 feet and 2.5 inches. The owner has made many interpretations of what the height should be based on the documents that were submitted to ISD. However, you have it from ISD's own memo that was submitted to the HDC, where the commissioner of ISD himself states that there's no doubt that the main house block as reconstructed is taller than the original structure. by 3.31 feet as measured by ISD and by the owner's own measurement by approximately 3 feet. Next, the owner claims that he should have been issued a certificate of non-applicability as opposed to a certificate of appropriateness. Keep in mind that the certificate of appropriateness was issued in September 10th of 2021. Really what the owner is saying is that back in September of 2021, he should have been issued that certificate of non-applicability and the certificate of appropriateness was issued to him in error. If that's the case he's making, he should have appealed that decision within that 20-day requirement that's under ordinance and statute from that September 10th, 2021 decision date, as opposed to trying to seek an appeal of that decision in February of 2021. I apologize. I've been referencing September of 2021, but it's September of 2020. I have my dates a little bit confused. Also, his reliance on...
I'm sorry to jump in because you did get me a little confused. Could you remind us again, the September?
Yes, I apologize. It's September 10th of 2020.
And which decision was that?
That is the decision that's depicted right here, which was the requirement that the main house block be rebuilt exactly as it existed prior to the collapse.
Thank you.
So, as I was mentioning, the owner's reliance on City Ordinance 22-40G6, which again is a ordinance that states if a structure is destroyed by firestorm or other disaster, the HDC shall issue a certificate of non-applicability. The reliance on that is misplaced, not only because it is not timely before this panel, but also if you look at the exact language, it says that it's a structure that's destroyed by firestorm or other disaster. Here's an image of the property, the main house block that was collapsed. This wasn't due to some act of God, something that was not in the control of the owner. This was not a fire. This was not a storm. This was because the owner didn't adequately secure the building during the renovations, which resulted in the loss of this historic structure. Lastly, the owner claims that the driveway as built next to the portion of the new house block is lower than what existed previously and showed pictures from the main street showing that the garage was in fact lower. Just to clarify and put this into context, this is a front view of the proposed garage and the existing main house block. You could see that the floor of the garage as well as the main house block are level, even in the same location. However, the as-built that was submitted by the owner shows that the garage actually is built 1 foot and 7 inches lower than the ground of the main house block. So that's the discrepancy you're seeing in the images where the garage does in fact look lower. Where the driveway is at the main house block is the same as it was at the time prior to the main house block's collapse. To say that the HDC never approved the height of the main house block is simply inaccurate. They called out the requirement that the main house block be reconstructed exactly in the same dimensions as what was lost. What happened here really isn't that difficult to understand. The owner was required to preserve a historic structure, and during construction failed to do that, which led to the loss of that historic structure, and then was required to rebuild it in the exact dimensions of what was lost. Rather than doing that, the owner built the main house block taller by approximately 3 feet than what was approved. Since the HDC's decision is based on ample evidence that's clearly on the record, the HDC's decision regarding the main house block should not be disturbed. As I mentioned at the beginning of my presentation, there are 2 decisions of the HDC from February 11th of 2021. Although both decisions had to do with violations at the property, they are distinguishable. Now, with regards to all of these underlying violations, these are the violations that on February 11, 2021 were found to be continuing, ongoing, and unremediated violations. And I'll take each one in turn, but before I do that, I need to speak to them generally. So first, we need to understand how we got here with these numerous amounts of violations. In the normal course, when an owner wants to construct a new exterior architectural feature or deviate from plans that were approved from a previously issued certificate of appropriateness, they need to go to the HDC. They need to seek approval. They need to seek review. And the HDC will issue either an amendment to the certificate of appropriateness, a new certificate of appropriateness, certificate of non-applicability, or certificate of hardship. However, that's not what was done here. The owner, on his own initiative, decided that he can make these changes. And the only explanation that was given to the HDC on why these changes were made was because, in his opinion, they were not viewable from the public way. Now, as I mentioned, there's a key distinction with regards to the second decision and the building height decision. The building height decision was a matter where the HDC made their first determination, their initial determination, that the as-built height of the main house block structure was taller than what was previously there, the historic house block structure that collapsed. On February 11, 2021, the HDC was not making a determination or new determination of violations. They were only looking at violations that they had previously determined to be inconsistent with certificates of appropriateness from a decision that they actually made on December 10th, 2020. Now, this distinction is critical because the question of whether or not the items that are underlined in this February 11, 2021 decision, whether or not they're viewable from the public way, they're not timely before this panel. As I noted, all of those items were found to be in violation on December 10th, 2020 at an HDC meeting. However, the owner never sought a review of the initial determination that the items were in fact in violation. Instead, he seeks to do so now and submitted the request roughly 2 months after the decision of the HDC for the December 10th, 2020 determination of violations was filed with the city clerk. Now, the reason that I say that the question of whether or not these items are viewable from the public way are not before the panel today is because, again, he didn't submit a request for review in December of 2020 when he was supposed to. If we were to permit him to now challenge the jurisdiction of the HDC for finding there are existing violations at this time, we'd basically be making the 20-day requirement of filing an appeal after the HDC decision to be moot. And we don't have to look far for an example of how that would play out in the real world. As I noted, the previous decision, the height decision, that is the first time that the HDC made a determination that the as-built height of the main house block is taller than what was approved in a previously issued certificate of appropriateness. The HDC concedes that appeal of that determination of violation is timely before the panel. However, now is the only time that the owner has the ability to request review of that decision. And what I mean is, let's say, for example, that determination by the HDC that the height is in fact in violation is upheld. The owner at some point is going to have to come back to the HDC for a determination that is no longer in violation. That can happen 3 months from now, 6 months from now, perhaps a year. And also he can come back numerous times because there's no guarantee that he's going to get that determination that is no longer in violation the first time he comes. To say that each time he comes to the HDC requesting that the HDC determine that the height is no longer in violation and say that he can then appeal within 20 days from that decision and then claim that the HDC had no authority to find that the height was in violation gives the owner infinite bites of the apple. Again, it makes it so that 20-day requirement for a HDC decision to be appealed, that jurisdictional requirement, it would make it moot. Not only is there procedural deficiencies, but also if you look at the actual images, and I'll go through each violation one by one, you'll see that the violations are in fact continuing and ongoing. They have not been remediated. The owner's only claim is that the items that were found in violation are not visible from the public way. However, the real question before the panel is whether or not these are in fact violations and whether or not they have been remediated. Basically, did the HDC act in an arbitrary and capricious manner in finding that these violations are continuing? The first violation that was found was a retaining wall. This was constructed without any HDC review or approval. Now, this is the stage right side view of the house. I apologize, I don't have a better picture of the retaining wall, but it's on the right side, about halfway along the length of the building. Again, this is what was built. There has been no effort to submit documents to remediate this wall that was built without any approval. The next violation that was found was again, same side of the house, the right side view of the basement windows and exposed foundation. This top image is taken from the approved plans from the HDC back in 2019. The below image is taken from the plans that were submitted of the as-built structure. You can clearly see the amount of exposed basement is significantly increased in the as-built, and not only that, there's additions of basement windows. This is an image of the structure as built that shows the significant grading and exposed basement as well as the basement windows themselves. Now, this is the view from the public way of Chestnut Street for the right elevation of the building. And there is indeed a fence. However, with regards to visibility, the HDC, like many other local historics in the Commonwealth, for the purpose of determining visibility, does not consider fences and landscaping to block lines of sight. The next item is the front view main house block, the space of between the molding and the freeze board. The owner conceded that this is indeed viewable from the public way. He, with no ability to disagree with it. There's no structure, temporary or otherwise, that's blocking the view from Chestnut Street. What we have on the left-hand side here is the approved plans back in 2019 for the renovation of the main house block. You can see that the windows actually go right up to the freeze board and abut it. On the right side is an image of the main house block when it collapsed. You can actually see that the windows are built into the freeze board. This is an image of the as-built structure. You can see a significant gap between the top of the window as well as to the bottom of the freeze board. Now, the owner had showed a graphic of how the building would look if it was actually set in the proper dimensions of the height of the main house block before it collapsed. And all he did was squish down the top story. What the owner did, if you look at the images, is quite clear. He added height at each different story. The very top of the peak, the second floor, and the first floor. It was gradual. So to show simply the top floor squished down doesn't properly represent what the height should look like. And a perfect example here is the difference in height of what was approved from the distance between the top of the windows to the bottom of the freeze board and what was actually built. The owner also conceded that the garage lights are not in the proper location. They are viewable from the public way. This is what was approved, and you can see that they're significantly higher. I previously showed this image of the front view of the garage floor. Again, the garage is clearly visible from the private way, the public way. And as I mentioned previously, it's at the same exact level as the main house block in the approved plans. However, in the as-built plans, and as you could have seen from the images that were shown by the owner in his presentation, the as-built garage is in fact lower than the main house block. The left view windows, this is an image on the right that's taken from the public way, and you can clearly see that the left side of the garage is visible. In the approved plans here on the left, there are 4 windows in this arrangement. However, in the as-built, there's a single window at the bottom. It's hard to make out here, but you can see the very top of it. This is the rear view of the building. What was approved is here on the left. You can see that it had 2 windows on the right, 2 in the left portion, and 1 door. On the right is the as-built structure. You can see that there's an additional door. The grading is significantly lower than what was approved in the approved plans. The window placement is not identical, and the number of windows is not what was approved. Additionally, there's a retaining wall and a set of stairs that were not previously approved. They're not in the plan whatsoever. And here's an image of them here. All of the decisions by the HDC with regards to this property from February 11, 2021 are just an attempt to bring this property into compliance. All of these violations, they were all done without any HDC review or approval. Because the violations are continuing ongoing, the HDC's determination decision from February 21st, 2021 should be upheld. Thank you.
Thank you. Thank you, Attorney Lee. If nobody objects, I'd like to ask some just quick chronological questions. I'll ask them of Attorney Lee first. Is that all right with everyone? I don't see anybody objecting. I'll go ahead. Just chronologically, I want to understand what the sequence of permits is. So do I have it correct? First, there was an approval on October 2019. That's correct?
Correct.
And that was the first time the HDC specified what the maximum height, what the dimensions would be. Let's focus particularly on the height.
That's correct. I would like to, it's a nuance, but it's an important one. They were not approving the height per se there. They were requiring the preservation of the main house block.
Okay. That was after the first proposal, which showed a completely different building, different facade and so forth. So the owner came back with a building that looked like a replication of the original building.
A building that preserved the main house block and did some minor renovations on it.
Okay. And then there was a collapse in August of 2020, September 10, if I have this correctly, 2020. So I have September and December 2020. I guess that's where I need clarification. Were there 2 separate decisions in 2020, one in September and one in December?
That's correct. So then let me back up. So you're right. In August of 2020, that's when the main house block collapsed. In September of 2020, that's when the HDC issued the certificate of appropriateness to rebuild the main house block as it existed prior to the collapse.
And then December 2020?
On December 10th, 2020 was when the HDC met to determine that there were existing violations. Now, again, to make it clear, the determination of existing violations, those were all of the items, plus a few that have since been resolved, that are set forth in the second decision, not the building height decision. As of December 10th, 2020, the HDC did not make a determination that the building height was in violation.
And that was new in the February 11th decision.
That's correct.
So then going back.
If I could just interrupt, was there also a decision in November, on November 11th, where the application was denied?
November 11th. I don't have any record of one from November 11th. Barbara, do you by any chance have a recollection of that?
Unmute myself here. Let me go back and look at the timeline. I don't remember.
That it was in the original packet. It was a record of action November 17th. At a scheduled meeting and public hearing on November 12th, the Newton Upper Falls, by roll call vote of 7-0, resolved to determine there is existing violation. That was Wait, that was November, but wait, I thought I saw the date was sent, the date of the notice sent was October 29. Was that just, wait a minute. I'm sorry, did you have did you talk about the November meeting, Joel?
I did not mention November. No, I was talking about December, maybe.
Well, November, it says it resolved that there's an existing violation.
Oh, I can clarify that. So then at the time of that existing violation in November, that was only with regards to the retaining wall. So the timeline that's in the memo is not incomplete, but it doesn't cover every single meeting that the owner for 959 Chestnut applied for. And I can clarify that there are a few that have to do with the violations that they simply were not remediated, the same way that they did for February 11th, 2021. Again, this goes back to my argument with regards to multiple bites of the apple, because the owner has actually come back to the HDC on 3 different occasions, trying to get a determination that the violations are remediated without offering any remediatory action. But with regards to November of 2020, that was determined that at that meeting, there was a determination that the retaining wall was in violation. Then on December 10th, 2020, there was a determination that the retaining wall was still in violation, as well as other items at the property that were in violation. The same ones are listed in February 11th, 2021.
Thank you. So the commission has been acting during this period. It wasn't in radio silence during the period from September to December.
Of 2020? No, there were items that had gone forward.
Okay, thank you. Sorry, Joe.
No, that's fine. That's fine. Thank you. Because I had noticed some other actions as well, so that's helpful. So I'm focused, well, primarily, Attorney Lee, because you were focused, not inappropriately at all, but on 2 decisions. So the October 2019 and September 2020 were approvals or issuance of certificates approving plans that showed preservation of the main house. And I want to be sure I understand correctly that in each instance, the commission was shown drawings that showed the height of the building that was proposed. Is that correct?
In each instance, they were, but they were the same plans that were approved in October of 2019. Those are the same plans that were shown in September of 2020, because please keep in mind, what was shown in the October 2019 plans was the dimensions of the main house block as it existed before the collapse.
I see. So they were presented, well, just as you said, showing the dimensions of the, let's call it the historic house. And I guess the representation was, so they were not plans of what was proposed, but what was represented was that essentially this is what we're going to build.
That's correct.
Fair to say. Okay, well, those are my factual questions for Attorney Lee. Does anyone else have questions for Attorney Lee? Marilyn, other questions? Or Charlie, do you have questions? Nope. So if I can, just on the same point, I'm sure I'll have lots of other questions. I'm looking very much at the big picture. So Mr. Sinani, if I could ask you, when you applied and received certificates in October of 2019 and December of 2020, you presented, let's say, architectural drawings of the historic house, and you were given permission to reconstruct or preserve the historic house. That's how Attorney Lee is presenting it. What do you say to that?
So for the September 10th, right? So Attorney Lee did show images of what we showed as the house height that was before. However, what was approved was differently. It was approved to reinforce the existing foundation. we would have had no issues with building the foundation as it was, but they did not want that. They wanted to reinforce. So therefore, the plans that you're seeing are before what was approved, right? So we go to a panel and we present what we want to. That's what was shared by Andrew. However, what was approved from that is different because we were told to no longer touch a rock foundation, keep it where it is and reinforce it, but build the same height. So now I am forced to work at the foundation exactly where it is and then build it so that it meets the height of what was submitted in 2019. Now, it's also very important to note that in 2019, the permit, and I want to share my screen. And this is the permit again from the, this loads. The permit was for full exterior renovation and gutted, restored main historic house. So everything exteriorly in 2019 was approved from the main house block as well as the full addition in the back. And we can see that by the building permit that I will pull up. It's just,
Well, okay, I don't want to see the building permit. We'll get to that later. I'm interested in the HDC decisions.
yes, so they agreed on full exterior renovation. So I think it's very important to note a couple of things, right? So when we look at this picture in 2019, so when we look at this picture, right, what was approved by the Newton Upper Falls Historical District was to remove the porch and make it smaller, change the roof design, remove the concrete porch. They also indicated to change the design of the bay roof to make it as it is on all the drawings, that it goes all the way to the window. Then they said different windows than what it was, different molding than what it was, different door than what it was. So they approved everything from windows, doors to molding. Every single item was approved in 2019. And that is reflected on all the drawings that Andrew shared.
Well, okay, I see Marilyn has her hand up, but I want to ask one other question. Can one of you show us the written decision from, well, both of them actually, but October 2019 and December September, I guess it is September 2020. I think I would find it helpful anyway to look at the certificates that were issued on those dates. And it doesn't have to be now. It's, Marilyn, if you want to go ahead and ask your question.
My question is this, excuse me. If the ISD or the town engineer imposes additional requirements to what is approved by the HDC, such as a higher or lower or wider or skinnier foundation, does the applicant have an obligation to go back to the HDC with revised plans? Or the revised requirement of the engineer or the inspectional services?
I can answer on my end. I'm told no. The ISD and historic, they have a conversation and they come up with a decision. So on my end, I don't have to do. So if for example, and I'll give you an example. So the complete underground water collection, that was something that ISD asked us to do. And it didn't matter what Newton Upper Falls said, it is a requirement. So we have to go what ISD says. Again, it's a little bit complicated because in a Newton Upper Falls meeting, we're proposing essentially what we want to do. Then we apply for the permit. That permit needs to get approved by the historical commission first. So they know exactly what's in the permit.
They do get a chance to see the whole set of drawings, and they get a chance to stamp the whole set of drawings. after the modifications are done, which they have already done that.
Then
Can
you
I-
get the
So-
permit.
So this is Barbara. So no, applicants are required to come back to the commission if there are going to be visible exterior changes based on what ISD says after they've reviewed the plans. Occasionally, if there's like storm drainage and it's really not going to be visible and there are minor things, we might sign off on that. But anything that was going to change, you know, the width of the building, the height of the building, the design of railings, anything like that, they would be required to submit an application for those changes.
I suspect Charlie's going to agree with you, and I'm not going to put Charlie on the spot just yet. What I'd like to do is continue this discussion of chronology so that we can understand what was in the two permits and then understand, what was in the two certificates from the HTC, and then understand when the building permits were issued. And Marilyn, then we can get back to your question specifically. So
I have the certificate.
Andrew,
I'd like me to share my screen.
thank you. Thank you.
Can you
I'll
see
be
that?
with you in 1 second. Yeah, hold on. Sorry, I just needed to change my lighting.
I could just ask before you leave this permit, and Joel, cut me off if I'm out of line here.
No.
It says, with the requirement that the final drawings and details will be complete and consistent, and will be submitted with final set of product and material out specifications to staff for final review and approval. Was this done?
Yes, that was done.
Yes. And that is what's also on the website, which is what I wanted to share.
Okay.
So everything needs to get, again, approved by Newton Commission staff prior to getting a permit. So you can never get a permit without not only the Newton Upper Falls approving it, but then providing all those plans to the Historic Commission again, and then they have to approve it again.
The approved plans that show the building height of the historic house block are the approved plans that are referenced here.
The survey height was presented to the commission staff and they signed off on it. So they signed off on the day of the when it was presented to ISD. Again, the first signature is historic, and they review all the content. They review engineering, they review survey, they review architectural drawings, they review material. They review everything in that application for a building permit. And they had to approve on the height from the surveyor. So they knew exactly what that height was. This is touching back in when I applied 6 months later in 2020.
So I would just like to say that we look at, and this is speaking on behalf of historic staff, we look at the elevations, we look at exterior architectural details. We do not get involved in interior structural drawings. We do not get involved in FAR calculations. That's not our area of purview.
To make it clear, plans that I'm referencing that were approved are the ones that I showed the image of the height at 21 feet and 10 3/4 inches. Those are documents that are submitted with the memo I drafted in full that show the plans, including the materials that were required that were actually signed off by the HDC.
Well, when I had asked earlier, the drawings that you showed in this presentation, I think you said those were just replicas of the historic house, not what the applicant was proposing to build.
There's two parts to it, right? Because that was all pursuant to this certificate that you see on the screen right now. The first part was renovation of the main house block. Renovation were just simply things like the siding and things of that nature, not demolition of the height or anything of that nature. The second portion was demolishing the rear addition and rebuilding it.
Yeah.
So the plans that I'm referencing, the ones from October 2019, again, the same date as this certificate, are the ones that show the main house block dimensions as they existed in 2019 prior to the collapse.
I do want to add a comment here. So there is no height ever submitted. Those are interior renderings of where a potential floor could be. So they have nothing to do with height. Completely nothing. It's interior measurements. And those measurements are not counted by ISD. They're not counted by anything. They're irrelevant because as soon as you apply for a permit, they need a certified land surveyor to provide height calculations. I cannot say that my house is 50 feet long, for example.
Well, I understand what
Joel?
you're saying right now.
Hey.
Yes.
Joel, can I make a suggestion that we have a little bit more control of the discussion here, and that you go ahead and continue your thought without interruptions from the staff or from the appellant?
Okay,
I
thank
think
you.
there's
Yeah,
a time
well,
and place for these clarifications and questions, but I think it's becoming disruptive that we're not able to develop a line of questioning here.
yeah, that's a good point. I guess, I mean, I know I do have a couple of questions, a couple more that will require responses, but I think, Charlie, to your point, we just.
Well, yeah, a response
need
for
it.
sure, but then we
Yeah.
don't need more and more.
Thank you. Yeah. Well, let me ask this question then. And Barbara and Charlie, Marilyn and Charlie, please jump in whenever you need. I'll ask this question for now. Then the certificate of appropriateness that was issued in September 2020, after the collapse, did that have with it, did it approve? Let's see. Thank you for putting that up. Why don't you give us a minute to read it? All right, so I'm going to read out loud here what's in bold. With the requirement that the dimensions will be reproduced exactly as they were, including the footprint and building height, the owners are required to come to the next regularly scheduled commission meeting with details and possible mock-ups for all of the trim details for the original structure, which must match exactly the existing historic details. No other work can be done on the main house block until the commission has reviewed and approved the trim details, including the porch trim details, bay trim details, fascia and soffit details, etc. So that's the board's decision of September 11, 2020. So that answers my questions. I just wanted I wanted to be clear on the permitting chronology, and now I'm clear.
If I could interrupt though, did they come to the next meeting, which would have been October 2020?
Yes, we've been in every meeting up until February.
And what happened at the October 20 meeting?
So what happened was they told us that the retainer wall that was built in the back of the house is in violation. So they made that a violation, and then they have pretty much denied every meeting from October, November, December, January, and January or February, saying that there is an existing violation. However, they placed a work stop order, so there was impossible for us to remediate it because we cannot remediate it. We can't even be at the house, technically speaking.
So plans, details, possibly mock-ups for all the trim details were never presented. Is that correct?
So all of this, correct, that were never presented, but they were all approved in 2019. So everything was approved in 2019 on the previous certificate.
But that's not what
And-
this says, right?
I know that's not what this says, but the issue is
Okay.
that the Newton Upper Falls told me that you have to reapply for everything. So when I showed that reapplication earlier, the application simply says, I'm reapplying to reapprove all the items that were previously approved. I'm not sure why we had to do that, but I get that
That's
was
okay.
the ask.
Thank you for the answer. I have a question, and that is, when was the building permit issued?
The first for the rear addition and the complete gut reno, or the second one of the collapse?
Thank you. After the collapse, yeah.
After the collapse, yes. Let me pull that up. So I'm going to share my screen. So these are, again, I'm using the Newton website, and these are the architectural plans. And these are the only two plans that show the footing, essentially, what are the dimensions. And this was submitted in September 14th.
When was the permit issued?
The permit was issued on the 18th.
18th.
And they used the surveyor calculations from the 2019, and these are the architectural plans of the footprint, which doesn't note any height here because, again, you cannot have height on an architectural drawing. It's not valid. They need the land surveyor for the height, and we used the 2019, which is, so again, I want to be very clear. You cannot get a permit approved without a land surveyor. And after we
Okay,
sent
yeah,
this to,
we understand that. I don't mean to interrupt.
That's not answering the question.
I'm sorry?
I think we're talking about something else, not the height at the moment. So if I may, the September certificate that Marilyn was referring to, I think she had a really good point that that was issued with a condition that the dimensions will be reproduced exactly as they were, and that includes the height, even if it was not specified. And the owners were required to come in to the next meeting with details for approval. And that appears not to have been done. Mr. Sanana, you referred to the retaining wall. That did not come up until the December meeting, according to the city's chronology. So I wonder what happened if there was a response that allowed the commission to see these trim details before. And then you got a building permit on September 18th. You went ahead to frame in the structure as allowed. But I wonder if you ever went back to the commission with these details that they required on September 11th.
Yes. So this is the October 8th. And if you look at 959, present trim details of the main house block and left side bay as required for the remediation plan for unauthorized demolition of the main house block and left side bay.
Well, that's the agenda of what actually happened.
What actually
Maybe
happened,
Barbara can answer.
they didn't review anything. They just said you're in violation. Here, I'll pull up the packet doc.
Barbara, can you speak to the question with regards to what happened at that meeting?
Yes, so they did come back with an application, and the commission, it basically got continued to the November meeting.
I'm actually presenting the full application with all the trim details.
So these are trim details and the like that were discussed but not approved.
That is correct. So the ask was to present this. I presented this, and then they looked at it and they said it's denied because there is a violation on the back of my house where there's a retainer wall.
So Barbara, did the commission deny this application or just continue it?
They just continued it. This is from the October meeting, correct? So it was continued.
Yes, right.
To the November meeting. The commission asked for more details, and I think specifically about the left side bay. And there were some other items that they wanted more details about.
And then meanwhile, the construction was continuing. So that during this
Correct.
period, the house was being framed up. And your expectation was that it was being framed up to replicate the house that had been demolished, right?
Correct, yes.
Were these details, exterior details, ever approved? No.
They were
Not,
approved.
sorry. Sorry, could you repeat that, please?
Were these exterior details ever approved?
Not in their entirety, no.
Okay, so
So for
Is
example,
for example,
so for example, the windows were approved. But for the most part, no, the details were not approved.
okay. And at some point, I think we know when, it was noticed that the house appeared to have a different height than what was approved. And did that come up at the December 10th meeting?
It did come up in the December 10th meeting, but there was no determination in the December 10th meeting.
Regarding the height, there were
Regarding the height, yes.
of other violations.
But then on December 18th, ISD issued a stop work order.
That's correct. In the stop work order, the basis of it was not a determination of that the height was in violation. It was the determination of all the other violations that were existing.
Okay.
So when did height first become an issue?
An
It's
issue
like February 11th. Yep, sorry.
Go ahead, Attorney Lee, you were going to say.
I believe Mr. Sullivan beat me to it, February 11th, 2021. That's the first time it was determined to be in a violation.
So I don't want to jump too far ahead, but Attorney Lee, I certainly took your point about many bites at the apple through subsequent return visits on older issues, but it does sound like February 11th was the first time that there was an order issued on the height. Is that correct?
That is correct.
Should we see if there are other comments or questions out there? Or-
Just one other thing first. So
Sure.
the height violation wasn't noted until February, but theoretically it was in place at least from December when the stop order was issued. Is that correct?
I wouldn't say it was in place. It was being investigated.
I'm
There was
sorry,
no-
what was the height was being investigated in December?
In December, that's correct. There was no formal determination that the height was in violation. It was suspected to be in violation, and there was further investigation that was being conducted.
Okay. And the December site visit with ISD was not on height. Is that correct? Or it
Not,
was?
not specifically on height, but through a drive-by, one of the HDC members noticed that there appeared to be numerous violations from what was approved. So height was one of the items they looked at, but it was also the other items that are listed on the December 10th decision.
Okay, thank you.
Should we see if there are other comments or questions out there? Ennis, do you?
Are we taking questions from the public? Or-
Well, that's good. Yeah, good clarification. I was thinking of not just yet the public, but other officials who I know are out there.
So the public comment was submitted in writing prior to the meeting, and you should have received that. If you haven't seen it, I can read out the 2 messages that we received. Would that be helpful? Or would you like to wait until after you hear from members of the Historic District Commission? And I believe they're Newton City councilors and planning staff who are in attendance tonight.
Well, I guess let's hear from any of the city officials if anyone wants to add anything new.
Sasha, can you confirm the best way for people listening to submit their questions?
Yes, people who are listening, you should be able to submit your questions through the Q&A feature. If you look at the bottom of your Zoom screen, there is a Q&A button, and you will be able to submit your questions there. If you'd like to ask your question verbally, you can also raise your hand. The raised hand button should be in the bottom left corner of your screen, and we will be able to allow you to speak. So either submit your question in writing via the Q&A, which is in the bottom middle of your Zoom screen, or raise your hand and we will unmute you.
Looks like we have a question from Jay Walter.
More of a comment. Thank you. I would like to, can you hear me?
We can hear you, yes.
Yeah, I would like to comment on the differences between what was built and the original building. As pointed out in Attorney Lee's photo of the existing and the original building. The heights of the roofs for the porch and the bay are considerably larger, and what was built, the heights between the windows and the roof, the heights between the floors, and these. And if you looked at that image, I have the original. I could put it on my screen if I would be allowed to share my screen. The proportion of the rectangle of the original building is clearly much different than the proportions of what was built. It's clear on the gable end facing the garage. Yeah, if you look at the blue rectangle on the left, which is the original building. You see how square it is? Now look at the rectangle, the blue rectangle on the building that was built. See how much more vertical that is? The horizontal dimensions are the same. It's the vertical height that's different, and that's accentuated there. Then you'll take a look, if you go back, Attorney Lee, yeah. If you look at the top of the window on the second floor to the bottom of the gable end, the blue line, the top of the window to the blue line, and then on the what was built, the top of the window to the blue line, okay? Then the bottom of that window to the roof line, and the bottom of the window to the roof line on the original building. Then if you scroll over, please. All the way. So you can see the height of the roof of the porch in the new construction compared to the height of the roof in the original building have nothing to do with each other. And then the height of the windows, the top of the windows to the roof eave has been pointed out fairly clearly by the counselor. So that what was built has nothing to do with the original building, and that was his purview. He was supposed to build it exactly the way it was originally built. Thank you.
Thank you. Go ahead, Mr. Sinani.
Yeah, so I would like to indicate, as I mentioned earlier, the whole driveway is the old driveway versus the new driveway. They have completely different dimensions. And I would also like to share an image, again, focusing on the details that were just mentioned. And I think it's very important to see the window here and the molding here, the porch, and the window right here. So everything shows exactly as what it used to be. And this is actually a good angle. With pictures, it's a little tough with angles, but visually we can see that everything is essentially exactly as where they are.
Well, Mr. Sinani, if I can just jump in here, I think it's clear that there's some, well, let me say this, it's clear to me, I don't want to speak for the other two panelists, it's clear to me that there's some very significant differences between what you built and the original building. And the original building that the commission asked you to preserve, what we need to get at is how that came about and just procedurally what that means for the Historic District Commission's decisions, and particularly the most recent order, especially that, because that's what's before us. But I understand how you came about to build what you built, but it is clear to me anyway that it's different from the original building, and you agree it's different as well because you pointed out some differences earlier. So I think that part's clear. We don't need to spend more time on that at this point anyway.
Jeffrey Ricklin, who's also with the Historic District Commission, has a hand raised.
Jeffrey, you should be able to unmute yourself.
Now you can hear me? Sorry. What I was saying is that we have two real dimensions that we looked at. The original drawings that were submitted were from height of first floor to ridge. And then the as-built drawings that were submitted were from height of first floor to ridge. And clearly the two dimensions were different by a distance of approximately 3 feet. For us, it wasn't an issue of where the benchmark is or where the grade is, but we were going from first floor height to ridge, first floor height to ridge. And those are two numbers that were just very easy to do math-wise. Thank you.
Marilyn, Charlie, did you have any other questions? I guess I have one question, and I'll let the city officials decide who wants to answer this, but what's the normal interaction between when somebody applies for a building permit, files a building permit application, how does ISD interact with the HDC? And I'm quite certain they don't go to HDC meetings, so it would be a staff interaction. How does that happen? And to what extent do they get plans, decisions, and so forth?
So the decisions are filed, this is Barbara speaking, the decisions are filed, scanned and filed into our permitting and zoning system. So they're on file there, but when ISD takes in the documentation for a building permit, they would send a copy of the submitted drawings for staff to review to confirm that they matched with the drawings that the commission approved.
And do you recall what happened here?
Yes, they did submit the drawings, and I reviewed the elevation drawings and the exterior architectural detail drawings, and that was signed off and approved.
And when was that?
Would have been, we got the final drawings in October 2019, so I believe it was November 2019, but I would have to check.
Uh-huh.
And what was the height on those, what was the height on those plans that you did sign off on?
That would have been the 21 feet, 10 3/4 inch height.
So you never approved of any plans that showed 24, 25, 26. Is that correct?
No, that's correct.
So, Mr. Sinani, did you say you had the 24-foot plans approved by ISD?
So again, ISD does not use architectural interior rendering as a height.
I'm talking about exterior, just to be clear.
There is no exterior height other than the height building, which shows the height from building being at close to 26 feet. That is the document that certified survey was sent to ISD, and then Barbara signed off on.
Well, now the survey would have shown, if you will, the footprint of the building, but I assume there are plans that show the height of the building.
The height is only on the survey. So I'm going to show again the documentation. So this is the only height documentation by law that's required in Newton. And in here, indicate exactly the height of every corner of the house, and then showing the building height, proposed building height at 25.5. This, of course, is different than the 26 right now because it's not counting for loam and grass. After we add the grass, it will be exactly at 25.48, which is what ISD approved and historic approved in July 8th, 2020.
Wait, so I think Barbara just said that she did not ever approve plans that showed a different height, and yet you're saying that she did approve of these plans that you're showing us right now?
Yes, there is no other option. Without her signature, these cannot go for the final approval at ISD. She's always the first person in a building permit that needs to sign off. So
Barbara, can you respond? I'm getting two different answers here.
So I would have signed off on the original drawings from 2019 that were submitted with the building permit, which I believe was in probably November 2019, but I would have to verify that. There would not have been an interim signature in July of 2020. So the next time we were looking at plans for historic to review would have been after the main house block collapsed. And we were looking at a proposal to rebuild that house block.
the procedure is a little bit different. So pretty much all of these documentations that you see here, Barbara should have access to, but the procedure is you provide all the documentation to ISD, then ISD will, as you can see in here, then historic, as you can see attached. So perfect, I found the right document. So this is the actual permit submitted in June 9th. And this was given to me after I got the permit. And as you can see, historic to see attached, which was approved. This is the actual building permit that I have. So historic, which I said is the first person that need to approve, was attached, was approved.
What was the attachment?
I don't know. I don't have that. It's something that they have internally.
So I don't have the document in front of me, but I'm going to guess that it would be a copy of the decision.
Oh, it's the architectural. This is the architectural plan building. These actually you'd have the.
So in June 20, they would have had, that would have been the October 2019 decision. The commission certificate before the collapse.
That is correct.
Well, so we're not getting anywhere with that, but I have this question for you, Mr. Sinani. So the commission decisions, based on what we just saw, clearly require you to reproduce, to reconstruct, if you will, once the building fell down, reconstruct the historic structure. So what was your thought process when you decided to not do exactly what that building was?
Yeah, I think it's important to note that they approved a different porch, different bay roof, different molding, different door, different windows, different siding, different everything. So that's what already was approved in 2019. Okay. When the historic building collapsed, we then went back, and for some weird reason, we had to reapply for the same material, but we were given the structure to be essentially built. When the structure was built, we presented the height calculations to ISD, and they said, based on the determination from the approved from Newton Upper Falls Historic, you need to match the same height as the submitted survey documentation. And that is exactly what we did. But not only the height, but also the footprint. So the length and width of it, it had to be identical. And that's exactly what we did. The other thing to note is the plans that we went to the historic commission on after the collapse show the height of 21 and 11 as an interior. That is different because that would assume that we use the same elevation of the foundation, but we weren't told to do that. We were told to use the existing foundation elevation.
I can add a little bit just to be more clear. So when the house collapsed, field stone collapsed with the house. So a portion of the foundation collapsed as well. So that's where Mario is referring to him going back with a new design to install a new cap and build the building from that elevation. So we got to keep in mind that the existing foundation as well, portion of it collapsed. A couple of feet of it collapsed with the house.
Right, but we understand that, but starting from the foundation, whatever level it got rebuilt at, the facade itself appears to be larger, higher than the original facade. And as Mr. J. Walter was commenting, and he showed that picture, particularly looking at the left side of the house, it's clear that that looks different from the left side of the original house.
Well, the left side of the house, I don't know if that was a question, but I'll jump in and try to clarify. The left side of the house, it is different because the drawings that they approved are also different. They did not approve the exact one back in 2019. They approved to redo those porches. The porches were supposed to be demo and redone, completely new from scratch.
Well, I guess we haven't seen the decisions approving those different designs. We saw some text that allowed for some modifications.
Well, the front elevation.
Question,
okay, I'm sorry.
Question, Joel. Going back to that certificate of appropriateness dated September 11th, 2020, when Mr. Sinani got approval to reframe and rebuild. Were there a set of plans or a different set of plans that were approved that were attached to that certificate that were used to apply for a building permit, different than what was approved at the previous certificate?
No, well, you have to understand what we presented was different than what was approved. Okay, so we presented and then it was approved to use the existing foundation.
In regards to the drawings, yes, there were when we went back to reapply for the rebuild, we only went back with structural drawings. So the historic commission saw and approved structural drawings. And those drawings did not know the height of the house.
Okay.
We can also see that here. So if we're, yep. These are the only documentations that were presented to ISD, and they, like as Barbara said, they all put them in here, and ISD and historic need to approve. So the architectural drawings show the wood, the decking, or I guess the framing, structural. This is only structural. This is only 2 pages. That's the only thing that was sent.
So ISD issued a building permit based on structural drawings that had no dimensions?
But they do have dimensions. So they have dimensions, and the height is on the height. Again, we have to use stamped. So these dimensions show length and width. So this is the footprint. Okay. And then for the height, the document that was in 2019, that's what ISD used.
So for height calculations, ISD uses a certified survey plan calculation that you calculate the height. They do not look at architectural drawings to define the height of a structure.
Well, but then what's your understanding of the language of the commission of the certificate of appropriateness, then that the dimensions will be reproduced exactly as they were, including the building, the footprint and building height?
That is what we did.
That's pretty specific.
No, we understand that, and that's why you the rectangle shape is the same. But again, the height of the building, because of the fieldstone had collapsed, you had to pick it up there. You could not bring that fieldstone and reinstall it so that you can raise the foundation of the building. And you could not do concrete foundation on this building because they wanted to preserve the fieldstone. So we saved what was there. We did not add the fieldstone that collapsed. So you're now starting the height of the building at the lower elevation.
Well, it seems to me that that's a significant difference in the visible part of the foundation, that's a detail that should have been clarified with the commission.
We did clarify that. This is the rock foundation that we told them of how this was going to get built. And this is the molding that goes, and this is the approximate grade. Everything is in here. Approximate grade, this is the molding that they want at the bottom. This is what was approved. This is what they wanted to approve. So we had to meet the same building dimensions that was there previously, and we have done that now. The only difference is, in order for us to save the rock foundation and use what was the existing and not add anything new, is the interior floor, as you can see, is lowered. But that has nothing to do from an exterior perspective. It is lowered because this is what was approved. As you can see, the interior floor is actually on an inside wall being held. It's not being held by the top of foundation at all.
But isn't there a fundamental difference in the height of the actual building from the foundation to the ridge line? Isn't your building 3 feet higher, give or take?
So
Or
there
from the
is,
first floor.
you're correct. There is a difference, a fundamental difference, but that's because the rock foundation also collapsed. And what we're not looking at right now is that 2 feet that collapsed from the rock foundation. Now you're basically starting the building at a lower elevation, and you had to meet the additions at the same elevation at that point, because you could not build this house at a lower peak. You had to meet the survey calculation peak.
Well, no, I'm talking about regardless of where the foundation is, you're measuring from the first floor, whether the foundation's at sea level or the foundation's 150 feet above sea level, you're measuring from the first floor to the peak. So the foundation is irrelevant.
Well, no, because you measure height based on elevations. It's not measured from first floor. There's no such thing as measuring height from the first floor.
Well, I understand that as a technical matter, you look at that, but I think every building, I mean, as a matter of zoning, right, there are height limits, and the height limits are measured in any event.
No, exactly. You bring up a good point. For example, zoning, the height limit is exactly measured by the survey calculation. And that's why City of Newton requires that. It's because of the zoning board and the height limits. And that's why you're required to hire a surveyor to do this kind of calculation. So in regards to the ISD, they're using the right documentation when they're looking at this that says proposed building height 25.5 feet. Because
okay, well, I think we're been round and round on that one. Charlie,
So can I ask one more question about height? So, Mr. Sonata, your contention is that the peak of the roof is at the same height as the peak of the roof of the original house?
Yes.
And that the
Correct.
house is taller because the foundation is lower?
Correct.
Correct. The peak is the same. Nothing has changed with the peak.
well, lots of things have changed, but the height of the peak is the same. I understand that, but it's the same height because the foundation dropped 3 feet.
Yes, due to the fact that we had to save the rock foundation, which was what was
Collapsed.
approved or collapsed. That's what
No, I understand. Yeah.
yeah.
So I'd like to ask Barbara if there was discussion at the commission meeting about saving this foundation or saving the remnant of this foundation. Was there any understanding about what that would do to the height of the structure built on it?
No, there was
What-
no
what-
discussion. So the commission did want to see the existing foundation preserved as much as possible, which is why they asked for it to be reinforced. But there was no discussion that the height would change.
So So the original foundation was stone all the way up to the sill of the structure? Because that's not typical.
I would
Um,
have to defer to either the architect or the builder on the commission, because they were the ones who looked at it.
Okay. I mean,
I don't know.
I don't know what the practice in Newton was, but in my experience, you know, there's stone below grade and there's brick above grade, and typically houses are not built flush to the ground the way this one was before it was demolished or before it collapsed. So I'm wondering whether the commission had ever had any discussion about the appropriate height of a foundation or the appropriate material for a foundation.
I don't believe that was discussed, no.
Okay. All right. Thank you.
Marilyn, Charlie, should we begin deliberation? Should we deliberate while the hearing's still open? Should we close the hearing?
Well, we do have Jeffrey Ricklin with a raised hand. I want to take
Thank you.
another.
As regards to the foundation, what the owner is basically saying is that the reason that the building is 3 feet higher is because the height of the foundation changed upwards of 3 feet. And if in fact that were the case, you would see more exposed foundation above the grade, because if you raise that foundation 2 or 3 feet, you're going to see more exposed foundation. And in fact, if you look at the drawings, you don't see 3 feet of foundation exposed. So I find it very hard to believe that the height of the building was changed because of the foundation. And I tend to agree with Jay that if you look at the left view of the building, you can see that really the height of the building itself changed more than foundation. Thank you.
Thank you.
May I make just 2 comments?
Sure.
So the first has to do with the statement by the owner that the ridge line of the as-built structure is the same as the ridge line in location of the historic structure, simply because they built it so that it meets the peak of the rear addition. The fact is the rear addition wasn't built at the same level of the peak of the main house block. You can see from the images in the sequence of events, the main house block was demolished before the rear addition was constructed. Where the HDC is also investigating whether or not the rear addition itself was actually built taller than what was permitted. That's not before you today, and I don't want to confuse anything, but it's very clear that the rear addition was not built at the time that the main house, the historic house block collapsed. So using that as a benchmark isn't accurate. Lastly, with regards, I mentioned it in the my presentation, but regardless if you're digging down 3 feet, which again, just from looking at the photographs, doesn't make any sense to say that the building is 3 feet lower as opposed to 3 feet higher. That's a significant amount of distance. It just doesn't stand to reason that after the collapse, they dug down 3 feet from where the house originally sat and then said, that's the reason why it looks taller. That's my last comment. Thank you.
Thank you. So panelists.
Joel, did you want me to read the 2 comments out loud, or did you all have a chance to read them?
I would like to hear them summarized.
Okay.
Well, I'll take a quick crack at it. It's to, well, go ahead, Ines.
Yeah, I'll just read it. So one, it comes from Alley Park, the rear abutter to 959 Chestnut Street. She writes that she strongly believes Mr. Sinani should be held accountable to build the house exactly to the approved plans. There have been violations after violations, with the most egregious one being the house. As it stands, the new drawings submitted show the current built home to be at least 3 feet taller than what Mr. Sinani originally submitted and approved. If this violation is allowed to move forward without consequences, it will set precedents for future developers to do the same. If there are no consequences, what will prevent the next developer from having a historic home fall over and subsequently build the new house 3 feet taller than the original? Many eyes are watching to see whether Mr. Sinani will be held accountable, and they will act accordingly to the outcome of this decision. Thank you all for your time on this matter. And the second one comes from Mary and Kathy Manzelli. They write, "Dear HDC, we have lived in Newton since 1968 and seen and heard a lot of construction being done around us, especially on High Street. This summer, I would think we will be hearing more from the project on the corner of Winter and Spring. With all the reconstruction that has been done over the years, especially within the past 15, it has been one noisy and dusty neighborhood to live in. Now that 959 has been put on hold and it's been forever, this is causing such a delay in completion that this is not fair to us as neighbors to have to look at what we consider an abandoned house with a chain link fence around it. Even though it's unfortunate that we did lose the Fleming's house, a piece of history, it's time to move on and get this reconstruction finished. We, as the neighbors that have lived here for a long time, and I'm sure the newcomers to the street would like to see this completed. Yes, there are some changes, but I have seen that on a lot of houses that have been redone around us. The front structure has not changed as the original, and I would think that would be the main focal point. It's going to be a beautiful house when finished, and I think Nikki and Sheila would have loved it."
Thank you. Well, I suggest we close the public hearing and perhaps give ourselves the opportunity to ask limited questions, but should we begin our discussion? Unless Marilyn or Charlie, you have other questions?
No.
All right, so we close the public hearing. Yeah, you out there? Should we close the public hearing?
Oh, yes, 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 I'm sorry.
Charlie?
Yes.
Okay, so
Yep.
three of us have informally voted to close the public hearing. And we'll begin our discussion and deliberation. I guess, Charlie, I have a question for you. And obviously you got into this a little bit, but would you mind talking a little bit more about how the interaction would occur, has occurred in your 30 years in Cambridge, between the building officials and the Historical Commission in Cambridge around building designs? My first question is, wouldn't you see an elevation? Wouldn't you get elevations with height?
Yes. Of course, we would want to see heights, dimension plans. But I think in this case, it was never anticipated that the original building would go away. And so that was not documented exactly initially. And I think that's understandable. But it certainly would have been a requirement, should have been a requirement, that before a certificate would be issued to reconstruct the building, that there be dimension plans and the details with dimension from the ground level and from the first floor and floor to floor up to the peak would have been a sort of a basic requirement, I guess.
So I'd say that the reason we're in this muddle is because they don't exist.
Well, I think there's a kind of an understandable confusion here. And you have to weigh what the certificate of appropriateness says versus in this situation, because the certificate's referring back to an original set of drawings that were not apparently dimensioned, that represented the original house, only to show this relationship to the addition. And then, so once that's gone away, subsequent permits or certificates refer to that need to replicate the original house. There's a little bit of a disconnect, I think, between the certificate and the actual plans, as there is a big disconnect between what was actually built.
Right. So, yeah, I mean, that's a good point that the expectation was that the house would be restored. And I guess when the house was no longer there, it didn't occur to anybody to ask for drawings to show what would be built. But the decision was pretty clear that the expectation was that the original house would be replicated.
With the same exact dimensions. I would have thought it, because of that language, that any subsequent drawings would necessarily have to show the dimensions so that they could be compared with the earlier building to show compliance with that requirement.
I agree.
Yeah, but then things get muddy because the owners got a building permit and built according to what their building permit said. And whether innocently or not, it's not for us to say, but didn't get all of those approved. And then we have that series of back and forth, really enforcement meetings with the commission, but they really weren't definitive. Turns out the height didn't become an issue until this February order that was appealed to us. And of course, that's the big one, but there were other definitely minor issues along the way.
Seems to me the issue is, that there's a certificate of appropriateness on September 11th, and a requirement for exact dimensions to be complied with. ISD issues a building permit on the 18th on what we've heard are a set of structural plans that we have not seen. And so that's still a question. What do those structural plans show? And whether or not the HDC staff or the commission saw those structural plans, which should have given dimensions. They should have been dimensioned floor to floor, first floor to peak, and showed the relationship to the foundation and the grade. So I think if that's an unanswered, I hate to say it, that may be an unanswered question is, did Mr. Sinani build his plans according to the plans that were attached to the building permit? And if not, I think that it would be definitive. If he did, and if those plans were on file with ISD and were reviewed or submitted for review to the HDC, then it's the HDC's problem. That's just with reference to the height, not to the other details.
And and I agree with all of that, Charlie. And it sounds like, sorry, it sounds like I assume, well, I guess I'm going on this bit of evidence, and that is that ISD has not issued a stop work order on its own. In other words, based on the owner builder not building according to the plans approved by ISD. ISD stepped in because the HDC asked them to, because he wasn't building according to their certificate.
Yeah. So, well, ISD, HDC has other violations in mind, not just height.
Yes.
So.
Well, I think that some of the other violations were probably a lot more obvious to people driving by. For example, that retaining wall, which was not approved, and then the number of windows or things like that that were patently not approved, as opposed to the height, which may not have been as obvious. But if I'm reading the statute correctly, all it takes is one violation for them to be able to stop the work and re-examine what's going on. Is that correct?
Yeah. Well, technically. I mean, again, I defer to Charlie for practice, but I think a lot of these could be addressed without stopping the work. You know, it depends on the scale of the violation. If it's height, well, yeah, but if it's, you know, some kind of trim issues, not worth stopping a project for that. Things that are readily fixed, retaining walls, and things that could be fixed by, might be landscaping, might be other kinds of issues. So I'd say it depends on the severity of the violation. What do you think, Charlie?
Yeah, I agree. But the height, I mean, the height is the primary violation here. I mean, that,
Yeah. I mean, there are a lot of interesting issues. We talked a bit about it on the site visit, but looking at the house, you know, the height, if you will, of the porch roof, right? If I remember correctly, the original roof was kind of slim, let's say, whereas I believe it was approved to have a roof on the porch that was a little higher, and therefore that has implications for the gap between that and the windows. And I can't remember if the windows were then made a little higher, and then that leads to the gap from the top of the windows to the frieze board and so forth. And those, some of those are among the violations, and others I believe were approved. But it's all a big ball of yarn, right? When you pull at one end of it, the whole thing unravels. I'm inclined that, as we've done in the past, we oftentimes will refer issues back to the commission, and we encourage both the commission and the applicant to actually talk to each other. I will say, and I address this particularly to you, Mr. Sinani, you're talking past the commission. You keep getting back to your survey issue, which I think is a legitimate point, but it strikes me anyway that you're not hearing some of the concrete points that the commission is making. And I don't know, the commission, what the commission members can do to focus on individual items like a punch list and try to have them addressed, but none of those will tackle the height of the house issue.
could, Joel, could we reopen the hearing to the extent of getting an answer to my question? I mean, Mr. Sinani showed us a table on a set of plans, but did not show us an elevation or a framing diagram that might have been dimensioned. And that set of plans is what he showed in response to my question about what was attached to the building permit and the certificate of appropriateness. You know, I think if we had an answer to that question, is what's in the ISD permit that would influence our decision.
Yeah, well,
So,
we can't reopen the hearing, but I did say, perhaps casually, but when we closed it, I said we reserve the right to ask discrete questions. And so maybe,
that's a question.
yeah, I think we can do it. And let me say this, because I think a couple of us asked, maybe all three of us at one time or another asked, and Mr. Sinani said several times, there was not an elevation. So if we can ask him a discrete kind of yes or no question, or we were pointed to that line where there were those lines at the bottom with data filled in, and that's what he pointed us to for the height, although I don't believe it was by way of saying the height of the structure. I believe it just talked about the elevation and not the elevation from the first floor.
Perhaps Mr. Sinani could show us that drawing again and show us the whole drawing.
Mr. Sinani, can you show us the relevant drawing or documents that address this issue?
We're promoting him to panelist so that he can do that.
Can you hear me?
Yes.
Yep.
Okay. So again,
So first, I'm sorry, Mr. Sinani, but if you could put up the drawing and then limit your comments, just point us to what's relevant.
Yep, so this is on the Newton website, 918, architectural drawings.
Yeah. So okay. So this is it.
Yes, this is the, and you guys can check this later.
And Mr.
There's
Sinani,
no,
go ahead, Charlie. If you can scroll down a little bit so we can see the structure on the right. Mr. Sinani pointed out, Charlie, that there's no elevation given on the right of the height of that wall.
Yeah, right there.
Yep.
Right there. Thank you. Yeah.
Okay, so right, no elevations, which I think is kind of bizarre. Honestly, I don't see how this could have been approved without knowing the floor to ceiling height and then the overall height. I mean, what Newton has a zoning code, right, that limits height of buildings, and wouldn't you expect the overall height to be here on this drawing?
I would.
Was this prepared by an architect?
Are there no other drawings other than this?
It's 2 pages. There's this other page as well here.
That's it. That's the whole
Building
basis
permit.
of, that's the whole basis of the building permit.
Yeah.
Yes, after the collapse.
There's the table at the bottom, Mr. Sinani. If you can scroll down and show us that table you've been showing us, just below this, I believe.
This one?
No, there's some calculations below that you've pointed to that shows elevation, but it's from sea level. There you go. Yeah.
This one.
Yeah, where is,
So they use this document as well attached to those 2 drawings.
So it's a surveyor's drawing, Charlie.
oh, was this part of the building permit? Was this submitted to the Historical Commission?
So this was submitted to ISD as a requirement. Historical had this image from 2019 or 2020, I should say, when the first building permit was approved. They had a copy of this, and it's also on the Newton website. It's also on.
Well, personally, I don't think that substitutes for a dimensioned elevation. That's a completely separate document. So, okay, that answers the question. Thank you very much.
You know, that table does, oh well, there was a line there that gave the building height. It said 24.46, I think. Here we go. There it is. Right below the line in red, it says proposed building height, 25.48.
Yeah, what the approved plans showed 21, 10, 3 and 3/4.
Yeah.
That's a discrepancy.
Yeah.
And
Were we saying, or did someone say that the height issue didn't come up until February?
Yes.
Because I'm not sure that's true. I'm looking at the record of action from December 15th. At a scheduled meeting on December 10, the Historic Commission said, resolved to send notice of violation to ISD for enforcement action and request that ISD confirm the height of the existing building compared to what was approved by hiring a licensed surveyor. So it was
December
on
10th.
their radar screen in December after the December 3rd site visit with ISD.
But Marilyn, here's the problem with that. It said to be confirmed by a licensed surveyor.
No, I understand that.
And the data that we have is from a surveyor and seems to conform with ISD's practices for measuring height, rather than looking at an elevation type height. They're looking at it in terms of survey data.
Which is a conflict with a certificate of appropriateness.
Yeah.
Yeah. So I'm wondering if HDC should have flagged this discrepancy.
HDC should what?
Have flagged, have
Flagged.
noticed
That was
this
the wording.
discrepancy. Yeah.
But as you pointed out at the outset, Charlie, we have an unusual situation where there never was an elevation. The only elevation was to replicate, or not to replicate, to simply restore an existing structure. That when the structure was gone, there was no blueprint, literally, to work from.
Yeah. Well, and I think, can I offer a conclusion at this point? I mean, we're deliberating. It seems to me that the framing drawing was deficient in it, that it did not show elevations. I think that should have been noticed. The separate table from the surveyor, I think it's beginning to ask a degree of clairvoyance from the HDC staff to have picked up on that separate document and applied that to the framing plan. So it seems to me that Mr. Sinani's building is clearly in violation of the certificate of appropriateness in terms of its height. That there may have been an oversight by the HDC or its staff in not picking up that discrepancy on the building permit plans. It's not clear that HDC staff saw those plans or saw that drawing or saw that table of dimensions from the surveyor. But I think that's where this comes about. Prior to all of this is the fact that the building collapsed while it was under construction. And I can think of at least 4 instances of this having happened in Cambridge over the past 10 or 12 years. And in each case, it's because the architectural drawings are way too ambitious for the type of structure that they're being put into. That it requires an extraordinary degree of care to reinforce an historic structure. Once you've gutted it out and removed all the interior framing and all the bracing, it requires extraordinary care to keep it from collapsing. And we've had at least 4 occasions in which a construction crew has been in a building doing renovations in that state, and the building has collapsed around them, or as soon as they had left the premises. And so this is a whole nother question which calls into question the responsibility of the designer and the contractor to ensure that this sort of thing doesn't happen. I mean, that the architectural plans for the replacement structure are adequate to support the historic structure, and that the construction practices are such that this is not allowed to happen. So Mr. Sinani said that this was a disaster. I think it was a disaster that was caused by human error, and so it does not qualify under the statutory definition that has been cited. Then there is also the questions subsequent to the height about the exterior detailing that varies from the approved plans. And I think that's pretty clear that those variances exist. There are degrees of public visibility, of course, but many, if not most of these alterations are visible from the public way. And so I think those are violations as well. So if I had to, well, I'm not going to go any further. I'll just leave it at that.
Well, thanks for that. I just want to footnote, it's a very minor point, but I think certainly struck me that from Ellis Street, the rear, you really couldn't see much at all. You could only see maybe the top 10 feet of the building. So I don't know.
I agree.
If I go along with
I
those
agree.
violations.
I agree, but you know, an historic district commission has to review those things and approve, and they approve plans, whether or not every element is visible from a public way. But if those plans aren't followed, that's a violation. You know, it doesn't matter. I mean, you can't put a plan that shows one arrangement of windows on a barely visible elevation or a not visible elevation and then build something completely different. That I don't think that's permissible.
I guess what I'd like to add to what Charlie said is that I think it is reasonable for a historic district commission member, when he sees when a decision is made that something will be to exact dimensions of what was there before, I think that commission member should be entitled to rely on that happening. In other words, without having to go, what they say now, into the weeds of a given set of plans and start calculating distance from here to here and from here to here and from here to here. If the decision that the commission made was it's got to be the exact dimensions, that's pretty clear to me. And except for perhaps the architects on the board, I would submit that it's not within the expertise or the expectation that an average historic district commissioner is going to be examining the plans and specifications to that detail. I think it is incumbent on the applicant, the ISD who receives the plans, and to determine whether the conditions of the certificate of appropriateness are met. And the fact that the certificate of appropriateness didn't say, by the way, the height has to be 21.7 and it turns out to be 26.4, I just don't think that it is reasonable to expect that that would have happened.
Yep, I agree.
Yeah. I guess where I'm stuck with all of this, and I agree with the points you both made, is that there's a big problem, and that is a building that's well on its way to being constructed, that's a few inches higher than was allowed. And what happens with that? And do we just make our decision and not worry about it, or do we try to? And I've been involved in lawsuits where, greater zoning violations have been involved, and the end result's not been a happy one for the building. Do we want to offer any thoughts? Do we want to? Well, I guess before we're done, we should actually go to the appeal request and the decision being appealed from, and kind of give yes, no answers as best we can. But I'd like for us, if we can, to come up with some thoughts at the end for a practical resolution, if that's the right word.
Well, I think we have to make our decision based on the evidence and not on the consequences.
Yeah,
we can discuss the consequences later, but
I agree. And I was thinking of it in exactly that sequence, that we make our decision and then see if we can So if we have a final word, if you will. So should we put on our glasses and get the decision in front of us? So well, let me read this out loud because so the application says we're looking to resolve all current violations at the site. We are providing true as-built drawings which captures all the items that are in current violation. We are also proposing changes to the current violations, and 8 are listed. I'll just read them. Basement windows, window, garage gable end, freeze board, 10 inches versus 8 inches, garage light location, rear house grade, basement wall and stairs, house height should reflect historic home, retainer wall, vents color. So that's all 8. And then the commission's decision is a paragraph I'll read. Resolved to deny a certificate of appropriateness for the applications as submitted for the changes that were done without commission review and approval on the basis that the existing violations at the subject property as determined at the January 14th, 2021 meeting are continuing and unremediated, and on the basis that the building height was determined to be in violation at the February 11th, 2021 meeting. The applications include, and then it just lists those items again, just with a little more detail. Until the violations are resolved, the applications cannot be resubmitted for review. The owner can resubmit the applications after the existing violations are remediated. Well, it's sort of a chicken and egg issue. It's saying fix it and then reapply. Well, if they're fixed, they need not reapply because then they'll be in compliance with the certificate.
Doesn't that imply that basically the building has to be taken down or cut down? And the windows that are not in the approved plans relocated?
Yes. Yeah.
Yeah. Do they have the authority to make that, to say that?
Well, I mean, yeah, so the commission issued a certificate and the building was built in violation of the certificate. All they're saying here is remediate. It's saying remediate the violations and come back and reapply. But as I said, it's sort of circular because if they remediate, they needn't reapply. So I don't know if there's a middle ground. I mean, some of these are minor. Obviously, the building height is major. So,
well, yeah.
With the and the applicant did acknowledge the violations. The application says we're looking to resolve all current violations at the site. And sounds like the meeting didn't go very well because the commission simply said, no, we got to fix them all. Some, as I said, are fixable, some not so much.
But isn't our decision a function of whether it was reasonable for them to say that?
You're right.
That without being
Yeah.
arbitrary or capricious or contrary to the law.
You're
So
absolutely right.
So I think what you said a minute ago is that they have the authority to do that, which means it wouldn't be against the law.
Yeah.
And their decisions and their request that the problems be remediated was a result of their reasonable, I think, determination that what was approved was not what was built. So setting aside the equities and the procedural issues and all the rest of the stuff, can we not? I don't know. I mean, aren't we there?
I think so. And I'll share this with you. As I was preparing for tonight, I was thinking, based on our site visit and listening to Mr. Sinani describe how the city requires the surveys, and from the surveys, they determine the height. I actually was convinced by that to a certain extent. In other words, I thought he had a good argument, was prepared to perhaps suggest a factual finding that said that his arriving at that height was supported by perhaps some miscommunication, which there seems to be anyway, but between ISD and the Historic District Commission. But going through the documents as we were tonight and pointed to that very clear language in those early decisions saying basically, here's your certificate. Your certificate is to first to preserve the historic structure, and after it collapsed, to replicate it. So I think that the ISD approach to determining height is really a red herring, because the actual height of the building from the first floor to the roof line is beside the point. In other words, whatever that number is beside the point, the order was to, or the certificate said, replicate what used to be there. And they haven't done that.
Well, I wonder, I mean, I'm inclined to uphold the HDC, that violations have occurred. They haven't been remedied. They may or may not have been made consciously. That's not for us to determine. But that there's certificate of appropriateness that requires the owner not to return until the violations have been remedied might be considered arbitrary, because it has this circularity that essentially requires him to demo a significant portion of his building before he can come back. And then when he's done that, he's in compliance after he demos and rebuilt. So while I think the commission could make a finding that would result in a requirement that the building be taken down, I'm not sure that this is the correct language that would require that or enable it. So I'm wondering if that's a direction we might take to uphold the commission's finding that the building is taller and that the other violations do occur, but that they need to take it back, consider it again, and issue a different finding, a different way of resolving the violation.
Yeah, that's perfectly put. And that really captures my thinking as well, because I think, and Marilyn, you were saying the same, there's really no way to argue with the commission's determination, but it's not a helpful order. And yeah, we should recommend that they grapple with it. And that the point I made 10 or so minutes ago is I think it'd be incumbent on both sides to look to engage in a dialogue and see if they can reach agreement on some important points, because each is talking really on different planes.
I think it's important to be able to uphold the sanctity, if you will, of the HTC process and the HTC decision and the certificate of appropriateness as the guiding document going forward. Because that's the whole basis of Historic District Commission decisions. So I think I agree with you on that part. I think it has to be on record that these violations occurred and that the owner, by his own documentation, has shown us that he chose to proceed against what had been approved.
Yes.
And maybe he was relying somewhat on ISD direction, but on the other hand, the HDC trumps the ISD. And I think at that point, the owner had an obligation to go back to the commission and say, wait a minute, I'm being told by one department at City Hall that I have to do this, and I'm being told by another department at City Hall I have to do this, and I need to figure out what to do. Instead, he proceeded at his own risk, which I think is a factor that should at least be acknowledged somewhere, that this was a voluntary decision on his part to proceed. At the same time, that I think we need to acknowledge that the HDC was acting within its authority to say no. But I do like your suggestions that we acknowledge all of this stuff, but then ask them to go back and reconsider what the solution to all of this is.
Yeah, I agree completely. The one thing I'd qualify a little differently, and it's irrelevant to all of your points, but an owner or a builder has to, it's not a question of one city department trumping another. You've got to comply with both. So if you get a building permit, you have to comply with the plans that you submitted. And it sounds like the detailed plans or the not so detailed plans submitted to ISD didn't show the facade, for instance, didn't have elevations. So he could build to some extent, but he's also required to comply with the conditions of the certificate of appropriateness. So it's a matter of having to comply with both sets of conditions. And to the extent that they're inconsistent, it's the owner or builder's obligation to make them consistent. It's not.
Yes.
Yeah. All right, so we're headed in a direction of denying the appeal, upholding the commission's finding. I think Charlie was the commission's findings that that there have been numerous violations. In fact, that's what you said, Marilyn, that violations have occurred and that the owner proceeded with the modifications that were inconsistent with the certificate of appropriateness. And he did so at his risk. And we, in upholding the commission's decision, we remand this matter back to the commission to, well, and I guess we add a sense, however, the commission's order was circular in that it ordered the owner to remediate all of the problems and then return to the commission, when in fact, if the owner were to remediate everything, there'd be no need to return. So we remanded to the commission to enter into a dialogue with the applicant, and we encourage the applicant to meet with the commission and discuss either total remediation or some hybrid of modifications and remediation for the two parties to discuss and hopefully reach some agreement. That makes sense?
Sounds like a motion.
Okay. Annis or somebody out there, did you capture all of that? Are you awake? Oh, there you are.
Yes. Could you repeat the piece about you're remanding it to enter a dialogue about whether they would either need total remediation, or what was the other option?
Or not total remediation, but to remand it, that we're remanding it to the commission with the hope that the applicant would meet with the commission and consider remediation of some of the violations, and that the commission consider areas where there may be room for compromise, reconsideration, and ultimately a modification of the certificate.
Well, I wouldn't go that far, actually, Joel. I would say remand it to the commission for reconsideration of their action denying. And then I think that reconciliation language is something that we can express after, but as part of a motion, I think it's clearer and cleaner just to remand it to them for a more direct and determination of the case.
Yeah, no, thank you. I went a little too far at the end there, so I retract that last piece. Yeah.
We'll have a kumbaya moment in a moment. But
Okay, so I have remand to the commission for reconsideration of the action denying, to provide more direct determination.
yeah,
Ennis, let me hear that again, please.
You're going to remand the decision back to the commission for reconsideration of the action denying the certificate of appropriateness and provide more direct determination of the case.
Well, yeah, well, but the first part of it is though that we uphold the findings of the commission, the findings of violations of the commission.
yeah.
And if we could just step back for a second, because the last part of your statement was a little bit unclear to me, and just ask the commission people and the applicant if they understand what that means, if they understand that they've got to talk to each other and see if there are ways to accommodate the needs of the commission at the same time, recognizing the hardships on the applicant if he has to tear down the building and start over.
Right.
Well, I think this speaks to my point, which is I think our finding and our determination ought to be much simpler than that. I think that we can follow this because I think we're finding, I mean, maybe not, we're making it, I suggested that their certificate, the language of their certificate made it arbitrary because it was circular. And I'm simply suggesting that they reconsider their decision and make a decision which is more direct in its nature and possible for the applicant to accomplish in a reasonable way. I'm still struggling for a way to express that more succinctly. I think period, full stop. And then we could follow that, I think, by a recommendation that people get back together and come up with a reasonable solution, but that's really up to the commission.
Yeah.
So,
yeah. So, Ennis,
I just think our finding should be simpler.
Yeah, but Ennis, to capture what Charlie said at the outset, so we have it stating that we uphold the findings, however I phrased it before, uphold the findings of the commission as to the violations, but we find the commission's ultimate decision to be arbitrary in that it is circular. And then I gave you some other language in there, but I didn't have the word arbitrary, and that's an important element. And then continue on with what we've been saying. So just to remind everyone, both the three of us and Annis and others who are listening, our practice is that Annis will prepare a draft decision that the three of us will review and fine tune to, it shouldn't say anything different from what we've been saying here, but just to capture what's here. And also, Annis, I'm reminded that this is being recorded. We could perhaps all listen to the last 10 minutes of this discussion to help us remember what we've said.
So it sounds like there are two key points. One is that you're upholding the findings of the commission as to the numerous violations and the fact that the owner proceeded with modifications inconsistent with the certificate of appropriateness at his own risk. However, you find that the decision language in the certificate, in the denial of the certificate, was arbitrary in that it was circular. And you want to end it there and then follow up with sort of recommendation on ways to work toward a more reasonable solution, or?
Well, I think, go ahead, Charlie.
I would suggest voting on that finding, and then we can have some more deliberation about remedies and perhaps have another finding that we could vote on, or perhaps not.
That's a good idea. Marilyn, are you ready to vote on just that piece of it?
Yes, I am.
All right, I take that as a motion from Charlie and a second from Marilyn. All in favor, say aye.
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 Oh, actually, you know, I've been counseling clients on this for a year. Since
Roll
it's
call
a Zoom,
vote.
thank you. Since it's a Zoom meeting, we need a roll call vote. So just say your name. So Charlie, Charles Sullivan, Marilyn Fenolosa.
Charles Sullivan, aye. Yep.
I'm Marilyn Fenolosa. I'm an aye.
Joel Bard, aye. All right.
So I would like to think there's a middle ground here somewhere. I mean, what Mr. Sinani's built is not an unattractive house. It may be inappropriate in the historic district, but it's not unattractive, and it's a substantial construction. I worry about commissions looking for vengeance, and there's clearly a violation here, but there clearly needs to be a proportional solution, which perhaps could stop short of demoing the house or doing major damage to it. And I think there are a lot of reasons to do that. You know, I think it could be coupled with an admission from Mr. Sinani and a forgiving attitude from the commission. But all these parties have to go ahead. Mr. Sinani intends to live on this property. He's going to be a resident of the historic district, and it would be a constructive thing for both sides to approach the resolution with an open mind.
Yeah, I agree. And I would add to that I mean, Mr. Sinani is, I can't think of the right word, but I used to be praised, that's not the word I was thinking of, for looking to initially restore and then to some extent replicate a historic house that evidently was badly in need of repair. And, you know, if he and the commission can find a good middle ground, it could be, it could be a positive for the district, because as we know, some of those older houses are lost because they get to be so far gone, nobody wants to undertake it. So, I mean, there can be a win-win here if the two sides can agree on all of these details. So do we, let's see, have a, instead of a motion, how about a resolution?
I was going to say resolution.
Oh, are you? All right.
I'm not going to offer it because you have said it wonderfully, but call it a resolution.
All right, so we're partway there. A resolution that the commission members encourage the applicant, our panel, the appellate board, encourage the applicant and the commission to meet with the objective of entering into a constructive dialogue with the intention of proposing and approving a design for the house which closely replicates the historic structure. Yeah.
But does not impose undue burdens on the applicant, given the state of the existing construction.
Good.
Yeah. So it's just a resolution. It's, yeah. Dennis, do you mind reading it when you're done?
Yeah, I'll second that.
A resolution that the review panel members encourage the applicant and commission to meet with the objective of entering into a constructive dialogue with the intention of proposing and approving a design for the house which closely replicates the historic structure but does not impose undue burdens on the applicant given the state of existing construction.
Yeah. Have a roll call vote.
Marilyn Fenolosa, aye.
Charles Sullivan, aye.
Joel Bard, aye.
So I'd like to add that a word to the commission that these gut rehab projects require an eagle eye and sometimes day-to-day surveillance, because as you saw, they can go south in a moment. And, ISD is not going to provide that. They don't usually give much attention to framing plans. And architects don't often or always understand how historic structures are framed and how fragile they are once the internal bracing is removed. So, and also that buildings like this that are vinyl sided should be documented before all of that exterior siding is removed. Just to sign off on a project while it's still sided without understanding what the original fabric looked like, which can be revealed by removing the vinyl and inspecting what's underneath, is a real oversight. And of course, then there's stuff like foundation issues. The code says foundations have to be, I think, at least 8 inches off grade, and there's a good reason for that, because you don't want your framing lumber that close to the earth. Once the old structure came down, the new structure of whatever dimension has to be practically constructed. And I think the detail that I saw of this new structure being so close to grade is going to cause it problems down the line. And finally, I think the commission should adopt a rule or a policy about the non-transparency or the transparency of shrubbery, which of course is ephemeral and disappears at some times of year, and fences. I think that'd be a really wise thing for all commissions to consider if they are in practice considering that fences don't interrupt a public view. They need to make that a specific criteria for their decisions.
Yeah, Charlie, on that point, I did see in Attorney Lee's submittal that we got in the last couple of days that evidently it's been the commission's practice, but just along the lines that you described, but it would be a good idea to document that as at a minimum as a policy.
Yep.
And I would add one other thing. Sorry.
Oh, sorry, go ahead.
I would add just one other thing, and that is to encourage staff at the commission and staff at the ISD to build a better relationship so that it doesn't take 3 months to get an engineer out there to measure it, so that it doesn't take a genius on the commission to try to figure out what all of these numbers on the ISD plans mean. I think the two commissions or the two bodies have to work together. And it's not clear to me that they were working together here, but rather on perhaps parallel lines that unfortunately didn't meet.
I'll second that one too.
We don't have to vote on it though. Well,
No,
I think we're done. Are we done?
we're done. Okay,
Dennis, are we done?
Yes, I have a few words of closing that I can finish us out with. So I'd like to conclude tonight's proceedings by reminding everyone who is in attendance to please sign into the chat with name, affiliation, and address if you haven't already done so. And I want to give a big thank you to our 3 panelists for your thoughtful consideration, the amount of time that you dedicate to this work, and the empathy that you bring to both sides of this process. It's been very educational for everyone involved, and we really appreciate your time. And I want to also thank the Barbara Kurtz, the Newton Preservation Planner, and the staff of Newton who have been helping make sure that this process has gone smoothly. And to all of the applicant and to the folks who have contributed their time to be part of this, we appreciate that. And all of the attendees who came and shared their knowledge and opinions to make this. Thank you.
Thank you.
Thank you.
We'll be writing up the decision and circulating it, and it will be filed with the city clerk's office.
Thank you.
Great. Thank you.
Thanks, everyone. Good night.
Night.
Good night.